Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, Senator Godfrey, the fifth county Van Jew, the son of folk, the ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we call here at the Third Timothy English Church of England, the King of Peace. It is May 14th, 2024, which is the Bowlby year equivalent 2974. I greet you in the name of my Queen, Sister Godwinson, from the House of Godwinson, as well as the officers of the Third Timothy English Church of England, Archbishop Belmont from the House of Belmont, and Bishop Countess Searcy from the House of Searcy, as well as all other officers, as well as members and inquirers, and all those who are striving to be members of this illustrious intellectual movement. I greet you here with another marvelous lecture based off the previous lecture that I brought before my people, with part three. Part three of the Exchequer of the Jews is in New Jersey, New Chancery Court. The Exchequer of the Jews are in New Jersey, Chancery Court. And we are using the United States case qualifier, Shively versus Bowlby. Shively versus Bowlby. If I'm pronouncing it wrong, if not, forgive me, you'll see it in a second. Okay, hold that thought. Right, so without further ado, let's get started with this marvelous lecture. Wait for my moderators to come on. All those who have questions, please post them. This is actually, like I said, a remnant of the last two that I did in regards to the Exchequer. All right, the Exchequer represents or mean in our uh, uh, reasoning here at the Third Timothy English Church is a current account. A current account. A current record. All right, a current account or a current record concerning all property, movable, non-movable, tangible, non-tangible. All right. This lecture, once again, part three of the Exchequer of the Jews is in New Jersey Chancery Court. We'll be using or interpreting Shively versus Bowlby, a United States Supreme Court case. We'll be talking about not just land rights, we'll be talking also about high water, low water marks in regards to property owners, as well as littoral and riparian rights as in regards to property owners. And let you all know that this is all a part of what we call the King's Radical Title. The King's Radical Title, which is results in what we call concrete estates and abstract estates, or concrete titles and abstract titles. Fee simple titles or intel titles, because all of them are dispensed from allodial ownership. Allodial ownership. If you watch some of the TikTok or the skips that were given by my officers, they make reference to those terms. Okay, so please uh, continue to inform yourself with the tempo information as well as the YouTube channel, which is very informative as well. All right, we will have literal documentation to give to the heirs and successors, as well as we also going to have stuff that you can actually purchase, lesson plans, uh, books, what else? Uh, Information in regards to the Anglo-Saxon Berwick Doctrine, in regards to the rules of law, rules of congregation, uh, rules of prohibition. All these things you need to make yourself aware of, because this is staked upon your invitation, your acknowledgement, and your participation of being members of this holy church. All right. So without further ado, let's get started with this beautiful and marvelous lecture that I, as your king, King Clifford Jefferson, ascendant of Godfrey, the fifth count of Anjou, son of Folk, ruler of Jerusalem. I advise all you at the sound of my voice to go to all the platforms that you see out there. And I'm going to name them: Sinetta TV, House of Awakening Minds, Moore Science Temple, the Canaanite Moors, uh, who else? Rod Hayes, all the influential uh, 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 podcasts out there. You need to really investigate what it is that you're receiving based off your understanding of some type of guidance to a future hereafter. Okay, you really need to question yourself, because it does not involve with the intellectual movement of the uh, Third to English Church of England, which is the incorporation of the royal peculiar of the crown through me, the officer of king, as the corporation. So I returned for all lands in regards to that being preserved in what we call intel estates, because crown land is in fact and is indeed intel. I am an Anglo-Saxon Berber king. Okay, Anglo-Saxon Berber king. All those who are unfamiliar with that, please view the previous lectures and podcasts that I have done on our channel. We have over 296 videos that you can view. We're going to start the school, or the church will be open. Church in the school will be opening soon. So all those who are inquiring, please make yourself known, as well as be studious to the notices that were given by Archbishop Belmont and Bishop Searcy in regards to the prerequisite for your being able to be part of this marvelous movement. That we'll move forward with this marvelous lecture. We apologize, Ms. Wright, for our tardiness on being able to get back to you. But if you have any questions in regards to what you have stated that you've been viewing on the videos, you will be able to bring them today. Okay. Uh, but if the questions are relative to anything that I'm not teaching on today, please hold them. And after class, we can raise those questions at that point. Okay. But once again, greetings to the Third to English Church, relative to the platform, which is the Third to English Church, which is the YouTube channel. Okay. So once again, greetings, welcome. All right. Let's get started with this marvelous lecture. Do you have any questions as of right now, Miss Wright? You hear me, Miss Wright, from the House of Wright? You have any questions thus far? I can answer one or two before we get started. Okay, all right. We're if any questions that you have in regards to what's going to be said today, please definitely bring them up. If there's anything based upon anything you heard prior in other lessons, then we can entertain those after this actual podcast. Okay. So once again, well, without further ado, let's get started. I'm pretty sure my moderators will be making their entry soon. Okay. And all those who are in, refrain from any bigotry or any dialogue that's unbecoming of us as part of this religious society. Okay. Okay. We can actually talk about it once we finish this class. Okay. I gave you a couple minutes to entertain your questions in regards to the past videos. Okay. All right. But for the sake of the class, we have to move forward. Now, in the past lectures in regards to the exchequer of the Jews, we've been talking about the history of the Jews. One specific group of Jews is the Ashkenazi Jews. Okay. The Ashkenazi Jews. We know the Ashkenazi Jews were those who go back to the Jewish diaspora. All right. When you're talking about the Jewish diaspora, you're going back to the time of the 700 BC. Okay. Approximately about 733 BC. Anytime this is right from the House of Right. Okay. But we're not going to go back that far. We're going to keep in the timeline, what we call the history of the Jews at the time of the 18th century. And we're going to go back prior to their introductory into what we call Edinburgh, Scotland. We're going to go back to the time of their entry into what we call England, now called Great Britain, which is through what we call William the Conqueror. William the Conqueror, the William the Bastard seed. Okay. William was also descendant of what we call the Robertines. The Robertines are descended down from what we call the House of Capet. The House of not part, so not the House of Capet. The Carolingians, the House of Robertinians are all associated with what we call the Carolingian and the Merovingian dynasty, which all got their start from what we call Clovis the First. Okay, Clovis, Clobis the First, and Clovis the First is associated with the Norsemen, Viking invaders who invaded the Isles of what they now call Great Britain, which was England. Okay, these goes back to your Frankish kings. All right, your Frankish kings. It's very important to just not to watch these videos, but actually do the investigations on what's presented in these videos, because I know they're coming from Wikipedia, but Wikipedia is a free source of free source that you can go to get a pretty much I'll say abstract uh, uh, view of what's going on, and the concrete can manifest just based off you going to the bullet points, such as the eyes listed in the brackets. These are your sources that makes them concrete. Okay, and we have to specify. When you say concrete, concrete doesn't necessarily mean concrete if you're dealing from the interpreter's perspective. Because as I always say here at the Third Timothy English Church, he who writes your books sets your timeline. Time never was when we were not. If the time of life and time become when we begin, the time will come when we would be no more. This is why you need a calendar. You need a calendar to chart your existence on this globe, or what we call the sphere, which is accomplished by water and earth. Water and earth. And we know water and earth is associated with that which consists of our environment, which we call the terrestrial sphere. And within that terrestrial sphere, we exist, all right, and what we call four continents, all right, four continents: North America, which you call it today, which was actually England, or what is what we now call or deem the Anglosphere. Okay, yes, the Anglosphere. Then you have what we call, based upon the TNO map, because if you look at what we call a sun cross, A sun cross has what we call a spear with a cross in the middle. Whether you want to turn the cross counterclockwise to make it look like an X, is all called a solar cross, okay? Which all the other crosses originated from. But when you're dealing with geography in regards to the mapping of our globe based upon those who wrote the story, they'll only give you based off that which goes back to discovery, all right? Conquest. And we know that the one who conquests or discovered is the one who's narrating the story. So based upon the narration of the story from the biblical perspective given by the British monarchs who ruled Great Britain as a result of what we call the Treaty of Union of 1707 to what we call the Union of the Crown in 1603, only resulted from the Treaty of Perpetual Peace and what we call 1503, which is a result of the alliance between Henry VII, the founder of the House of Tudors, and King James IV, descendant of the Scottish monarch. And we know the Scottish monarch were the ones who were living in Scotland. And we know Scotland is associated with Edinburgh. When you go back to Edinburgh, Edinburgh is one of the territories that the Oscar Nazi Jews, which is called the Jews who migrated to Scotland and Edinburgh in the 18th century, actually came from the Jewish diaspora in what we call the 700 BC, when they were expelled as a result of what we call, what's his name, Tiglath-Pileser, the Babylonian and Syrian deity. Okay, everybody knows that story. Okay, so it's very important to understand time, all right? We all think of this concept of time as what we call time immemorial, time at a mind, where time where we cannot remember, okay? Time where we cannot remember. So when you're dealing with the Jews, because we know that the Jews were associated with Jacob, who name became Israel, which is known to the 12 tribes of Israel, okay? And the 12 tribes of Israel is not those who are taking that banner and running with it today. Because we know from a concrete contrast to the abstract story, we know that the ones who mostly or closely identify with the true Jews based off a body of politics, all right? Very important. A body of politics is definitely different from a religious practice, okay? Because religious practice without a body of politics is just a belief in the spook without no protection in the government based upon some law passed by that religious government that's associated with God. Everybody must understand that, all right? Everybody must understand that. Because when the King James, the one who wrote the 1611 Bible, he was a monarch of Scotland, okay? He was a king living off the divine rights of a king based off his presumption or assumption of prescription of sovereignty or acquisition of sovereignty, which is nothing more than the assuming that they are the sovereign. We know the true sovereign from everybody's religious perspective is God. Whatever you call him is assumed to be God, okay? And we know God etymology means government ordinance department, okay? This is why when you go in any judicial forum in regard to the protection of laws passed by the legislative branch and upheld by the executive branch, the judicial branch is there to give remedy, okay? To give remedy. If there's a separation of church and state, you have no remedy under religious right. It's a belief. They wouldn't care what you believed in because it's your preference. It's whatever you want. But it has no protection at law unless it's protected by a government. So if you claim to be part of religion and worship of God, then that God must be incorporated in the government. If it's not, then brothers and sisters, you have no protection at all. Okay? So when we look at the history concerning the Jewish diaspora, we know concerning the Jewish diaspora, this was the story told by the Knights of Crusaders, going back to the Knights of Templars, going back to what we call the Kingdom of Jerusalem. We know that the first concrete story of the Kingdom of Jerusalem versus the abstract story of the Kingdom of Jerusalem that you hear in your Bible was ruled under Godfrey of Bouillon, son of Eustace II, from the House of Flanders. who married Golda of England, the daughter of Ethelred the Unready. Okay, the son of our Jesus Christ, King Edgar the Peaceful, which I am the reincarnation of. So the what we call the Church of the Holy Sepulchre, okay, and the Kingdom of England, which protected the sanctity of the Church Holy Sepulchre, as well as the Shroud of Turning, as well as we call the Crown of Thorns, that goes back to the Kingdom of Jerusalem. And the first Kingdom of Jerusalem, that was under the authority of what we call the Pope, going all the way back to Constantinople, was Godfrey of Bouillon. Godfrey of Bouillon never wore a crown because he said that, how can I wear a crown when the state was subject to a crown of thorns? The crown of thorns story goes back to the guy by the name of Godfrey de Charnay, who was one of the Crusaders, who was related to Stefan of Blois, who is family with Empress Matilda, and Empress Matilda was the wife of Godfrey V, Count of Anjou, son of Folk, the ruler of Jerusalem, where his son Godfrey the Plantagenet Godfrey V of Count of Plantagenet is where the Jefferson surname descended down from, which is my surname, because Jeffrey, and we know son is the prefix, which is one of the highest prefixes that you can have in regards to descent. Okay, so without further ado, let's get back into the history of the Jews in Scotland and the Jews in England, because before you can deal with the Jews in Scotland, before they were expelled from Scotland through the edict of expulsion by Edward I of the Plantagenet crown, son of Henry III, we have to deal with them how they first enter in what we call England, which is now called Great Britain. And that came through the invasion of William the Conqueror. Okay? William the Conqueror. And William the Conqueror was not an English king. He was not a French king. He was a Frankish, Nordic, Carolingian, Merovingian king. Okay? You must understand that. Without further ado, I know I talk too much, but forgive me. History of the Jews in Scotland. The history of the Jews in Scotland goes back to at least the 17th century. It is not known when Jews first arrived in Scotland, not known. But the earliest concrete, remember, I talk about abstract and concrete. Concrete means able to be proven, all right? Abstract means it's presumptuous at best, all right? That's the way the courts under common law works, all right? It's under what we call presumption of a fact, all right? A presumption can be over or what we call superseded by what we call a basic fact, okay? An evidentiary fact, because the presumption of fact is not a fact. It's assumed to be a fact because it's not been attested, okay? It's not been attested. So when we attest the facts that history is told of based off he who wrote the story, it must be separated from the abstract versus the concrete. So I didn't even write this, and they're talking about a concrete historical reference to a Jewish presence in Scotland in the late 17th century. Okay? In the late 17th century. Here's your source that you can use to qualify Jews in Scotland. Scottish Church History of Society, page 196 to 209. I'm not going to reference those because it'll take up my time for those disqualified. Go to that source and verify. Okay. All right. Most Scottish Jews today are Ashkenazi Jews. Background who mainly settled in Edinburgh, then in Glasgow, in the mid-19th century. This is when they have what we call the Scottish diaspora. We know when we say diaspora, we're talking about the migrating or the immigrating of a group of people. Okay? That's what that means. In 2013, the Edinburgh Jewish Studies Network created an online exhibition based on archival holdings and maps in the National Library of Scotland, exploring the influence of the community on the city. Okay. Any question, Mrs. Wright from the House of Wright? Please let me know. First paragraph is what we're going to concentrate on. There's only scant evidence of a Jewish president in medieval Scotland. Okay, so we're talking about Jewish in Scotland. So this we make reference to Scottish Jews, and they said the first Jews in Scotland were the Ashkenazi Jews. Okay, the Ashkenazi Jews. We must remember that this is not prejudice. I'm not going against any group of society based off their belief. I'm only proving based off the current account of the record associated with the Anglo-Saxon Berbers associated with property, movable property, non-movable property, intangible property, non-tangible property, real estate or tangible estates or estates and lands that are subject to the allodial ownership of the crown, who is personified by the king under what we call a radical title. A radical title, which also encompasses what we call high water mark, low water mark, littoral rights, and riparian rights. Okay, dealing with water rights, we already understand land rights, because land rights is allodial subject to estates at tenure, either occupied by, under the North American preference, what we call fee simple, which comes in three forms. It comes in what we call fee simple, absolute fee simple, or life is what's it? Fee simple, was it fee simple, defeasible estates, and life estates. Okay, I know a lot of you might not understand these terms, but you have to come to class. Okay, so in North America, it's called fee simple, defeasible estates, and life of the state, which means that they all have encumbrances. Okay, they all are subject to easement. You have the right of enjoyment. Okay, an enjoyment of a non or what they call a non-possessory use and property that you don't own, because ownership is allodial, means free and clear. Okay, free and clear. If you own a lot and block number, then you don't own anything. Okay, it is subject to the eminent domain power of whatever colony or state that you're a resident of. Okay, and we know that because of the account that, or the current account, i.e., the exchequer, is held on what we call an escrow account. An escrow account is what the account is created by what we call stakeholders. Your stakeholders work for your shareholders or your stockholders, which are your investors. So when you buy property, three things, what they call the Trinity, must come to play. You have a mortgage, you have insurance, and you have a loan. You have a mortgage, and for you to get a mortgage, you must have a loan. All right? The loan is to ensure, once the mortgage is done, that if any lien is put on that said property that was conveyed for you by the broker, i.e., the escrow agent, that means that you can be refunded to a maximum amount by the insurance company. Okay? Hope everyone understands that. Okay? All this goes back to ownership of real estate, which they call, in any real estate preference, estates and land, which they associate what they call a bundle of rights. Okay? A bundle of rights is associated with a bundle of sticks. A bundle of sticks are sticks that are picked up and wrapped up in a bundle, which represents different types of interest in real estate property. Okay? But without going into that, it says from the Middle Ages to the union with England, there is only scanty evidence of Jewish presence in medieval Scotland, which means the lands of the Scots. And then the 80 Bishop of Glasgow forbade churchmen to ledge their benefices for money borrowed from Jews. This was around the time of the anti-Jewish riots in England. And so it is possible that Jews may have arrived in Scotland as refugees, or it may refer to Jewish domicile in England from Scots. Pardon me, read that sentence again. This was around the time of the anti-Jewish riots in England, and so it is possible that Jews may have arrived in Scotland as refugees, or it may refer to Jewish domicile in England from whom Scots were borrowing money. We know the Scots were what we call the goldsmith or the gold bankers, all right, and were subject to what we call the barons of Exchequer. The barons were Exchequers were the ones who are judges who oversee the Exchequer, or what we call the current account, dealing with all fines coming in to the courts of Exchequer, which originated from the courts of common pleas. The courts of common pleas originated from what we call the king's revenue. Okay, it was part of what we call the king's revenue. If you miss those interpretations of those words, you have to go back and watch the past 6 lessons that I did. Okay, the past 6 lessons that I did. This makes the 6th lesson. All right, 3 on the exchequer and 3 on the edict of expulsion. All right, so you got to watch those to be pretty much caught up. So when we're dealing with the Jews in Scotland, i.e., the Ashkenazi Jews in the 18th century, it goes back to the anti-Semitic riots in England. Okay, pretty much what's going on today between the Arabs and the Jews. Okay, which composes of the Shemitic tribes and the tribes of Japhites. And we know Japheth and Shem were the sons of Noah. Then you had Ham or Cam. Cam is the 3rd son. I mean, not the 3rd son, but one of the sons of Noah. And we know that the one who's telling the story is the one who descended down from Japheth. Japheth was the father of Gomer, which Ashkenaz descended down from, which where you get the Ashkenazi Jews. Okay, and they got a history in England before their history in Scotland. Okay, all right, because we talking about the first Jews in Scotland, based on the evidence of Bishop of Glasgow forbade churchmen to ledge their benefices for money borrowing from Jews based upon the history that they had in England going back to the anti-Semitic Jewish riot. So let's visit that real quick before we go on to what we to Ashkenazi Jews, right? The first Jews in England arrived after the Norman conquest of the country by William the Conqueror in 1066. We know in 1066 is where you get your first English Freaknow year. Prior to that, all the years from 80 to BC were Berber calendar was in use. Okay, from 1065 going all the way back to time immemorial, the only calendar that was in use, based off the only calendars that are in question. I'm not talking about the Jewish calendar. I'm not talking about any other nation's calendar. True story that we're talking about, calendar we're talking about right now, is between the Anglo-Saxon Berbers and those who are deeming to be Anglo-Saxon of English descent. And we know that the English Freaknow year started with William the Conqueror, when William the Conqueror invaded England, and he invaded England with the Jews, because the Jews came into England with William the Conqueror, based off the concrete evidence that we're reading here. And we're using Wikipedia, but you can go to the source to verify. All right, Ross, 1964, page 4. The first Jews in England arrived after the Norman conquest of 1066. The first written record of the Jewish settlement in England dates from 1070 Jews suffered massacre in 1189, and after a period of rising persecution, all Jews were expelled from England after the Edict of Expulsion in 1290. Okay, so with that, as you can see over in the brackets, this is the history pertaining to the Ashkenazi Jews, all right, pertaining to their time in England and Scotland. We're not going back to the time era going back to the Jewish diaspora, because only records we have there to prove that or attest that evidence to that existence is the biblical events written by the Scottish kings who are unquestioned in regards to the validity of that story written in your Bible, okay, in 1611. Because in 1611, they were operating under a commonwealth, and under the commonwealth, there is no parliament in functioning now. I mean, pardon, so there is no king in parliament functioning now. It's only the parliament functioning. Why? Because the Parliament of England and Ireland and Scotland united in 1707, which means that the only minor position that could be sitting as a result of the unification of England, Ireland, and Scotland was the minor of Scotland, which started with King James VI, Charles I, Charles II, and William III, William, Queen Anne, George I, George II, George III, all the way up to Charles III we have now, okay, which is a German minor, okay? But to trace the history from them, we must go back in time, which we call time out of mind, which we say is time immemorial, which we're doing right now. So we're going back into the year of 1066, according to the written record, based on the concrete evidence. The physical body cannot go there because the physical body cannot travel through time and space, meaning that the physical body that's made of matter, i.e., mass, cannot go. The only body that can go with the mind is the body made of antimatter, which is a body of what we call ether. Okay, ether, which it consists of what we call antimatter. Okay, antimatter is what we call ether. Ether is that exists before the state of matter. This is why you have the states of what we call general theory of relativity and special theory of relativity, because through that transition to what we call out of body experience, going back to 1066, involves what we call a vacuum. Okay, a vacuum is a suction. All right, is a suction to be able to pull that energy through that vacuum, in which we call a wormhole. All right, a wormhole, which you call space time. Space time deals with moving from three-dimensional to fourth-dimensional under the same time continuum. The time continuum is past, your present, and then the future. Okay? The time continuum is the past, the present, and the future. We forgot the past. We're stuck in the future without a past, thus brings no future, because a future, a present without a past has no future. Okay? You're subject whatever randomly. Okay? Because you have no instructions. Okay? So through the lesson that you receive here at the Third Timothy English Church of England, it puts you in a position to travel through space time, okay? Through space and time under the same time continuum from the present to the past without even taking the body there, okay? Through the record, the evidence that was preserved from those who lived in that past but who are no longer here. Okay? That's what I mean by the exchequer, the current account, the current record. Because once again, he who writes your books, set your timeline. Time never was when we were not. If the life of time becomes when we begin, the time will come when we will be no more. Okay? Like the checkerboard behind you. You'll see the allodial land. Let me just unshare my screen. The landmass that you see here is the allodial land. All the boxes on the allodial land is called estates and land, which are called land tenures. all right? And the land tenures is only for the heirs, all right? Which you can see those who can either be de jure heirs or those can be de facto heirs. You see de jure heirs on one side and de facto heirs on the other side, okay? The jure heirs are the ones behind me. The ones who are de facto are the ones who are ahead of me, because the ones who are behind me are the ones who honor their king. This goes back to the understanding of body of politics. Okay? The body of politics. You give up some of your sovereignty, all right, for those who you pick who were sovereign to represent the sovereignty, because sovereignty is the ability to be the hierarchy of a state, to make their law, to amend their laws for the benefit of the public, what we call the public welfare. Okay? The public welfare is what you call the welfare of the public, or what you call the public domain. The public domain or the republic is called the commonwealth. Why? Because it's being looked at after by the government, while the king is in the interregnum. Because under interregnum, there is no English monarch ruling for the Kingdom of England. The only monarchs that are ruling under the Kingdom of England are the Scottish kings, okay? King James, and he got that ascension to the House of Tudors to Henry VII and Henry VIII. Henry VII got his authority from conquest, all right? And when you see conquest, that means that somebody came on the allodial land to write a conquest, which we call prescription of sovereignty. And the prescription of sovereignty is when somebody claims to be sovereign and it has not been attested. And it has not been attested because there was no demand from one English king to the next English king. The interregnum came under under the Wars of the Roses, all right? When Henry VIII, Henry VII took over the Lancaster branch of the cadet branch of the Plantagenet crown that was established by Godfrey the Fifth Count of Anjou, son of Folk, ruler of Jerusalem. This is where you got, prior to the 100-Year War, the War of the Roses, you got the first 100-Year War or in the second 100-Year War, okay? Then you had the War of the Roses, which was a conflict between the Yorks and the Lancasters, which are cadet branches of the Plantagenet crown, okay? Which controlled Normandy, the Duchess of Normandy. They control France. They control Jerusalem, which we're going to prove today. Okay? Okay. Oh, yeah, let me go back. All right. So based off the checkerboard that you see behind me, the checkerboard that you see, whether they're black or white, represents what they call estates and land, or what you typically call a lot and block. All right? When you go outside, when you go into the next box, if you're standing in the white block and you go into a black box, that's stepping on somebody else's property. All right? You're stepping on somebody else's property. All right? That's what they call boundary line. Okay? Boundary line. All right? Now, these are what they call fee simple estates. All right? They can be fee simple, defeasible, and life estate. All right? Subject to encumbrances of the owner, which is the one who owns all the territory. It can either be the one who truly owns it de jure or the ones who own it de facto. How you can prove which owns it de jure or de facto is by understanding the difference between de jure and de facto concerning sovereignty. Sovereignty, as I said, is the ability of the sovereign to control. Okay. So the boxes represent estates and land that were granted by a charter from the grantor to you, the grantee. Okay? From you, the grantee. If anybody who's watching this video have a house, live in an apartment complex, live in a residential area, I don't care where you live at, farm, etc. All right? You live in one of these boxes. Okay? No. No. A land patent and a land grant is not the same as lodio. The lodio is what I'm talking about, the square. It's the square that you see here. Okay? Each box you see represents estates and land which can only be acquired through a land patent or a land grant. Does that make sense? I'll wait for you to answer that question. The box represents the allodial land, okay? Which can be owned by one person. No group of people can own land allodial. Only one person can own the land allodial, and that's the king or the minor. If the king's not there, then all land is back to the crown. All right. The crown is called a corporation sole. So if anybody has an estate, whether the box is black or white, that is called an estate and land. And what represents that estate and land is that deed you have in your possession. That is an instrument of conveyance from somebody who granted it to you and you as the grantee. All right. But the person who granted it to you was not the owner because you got it through either a landlord if you're dealing with a rental agreement, or you got it from a broker, if you're dealing with from a real estate, or you got it from a agent of the state, if you're dealing from a foreclosure. Okay. And those are what we call land grants or land patents. Those are not called land grants or land patents. Those are instruments of conveyance of what they call uh uh what they call abstract deeds. They're called an abstract deed because they can't prove that the chain of title is clear. Why? Because if the monarch is not there, that means that the land is not allodial. That means that whoever's on the land is using the land other than how it's supposed to be used. And that's through what they call fee simple. Fee simple comes through what we call prescription of sovereignty or acquisition of sovereignty, or what we call right of conquest. All right. So the other person on the side of this board has taken over the land by prescription, acquisition, right of conquest, or simply a better term you can understand it by what we call eminent domain. Eminent domain. When there's eminent domain, they say when they got here, was nobody here. The land was just sitting here. So they took it, right? They took private property for public use. When they took the private property from public use, then they started making money off it by giving estates and land by way of creating some instrument called a deed. All right? It's called a deed. When you create a deed, you got that deed from a broker. A broker is the one who licensed to sell real estate. All right. Once again, Sister Wright from the House of Wright. These questions, I'm going to have to wait because it's going to take me away from the lesson. Okay. All right. So, but hopefully this was self-explanatory. Self-explanatory. So all the estates that you see in white or black are estates and land, and the only way you can have an estate and land and a de jure in a valid way of ownership is by way of you possessing it by way of a land grant, which is called a charter from the original grantor, the true owner, the absolute owner, and the only absolute owner is the one who owns all the land, not just a parcel of land or one box or two boxes or three boxes. Because you only have an interest in those three boxes where all the other land is considered vacant, then that means that the one who owns the vacant land has more supremacy than you do. Okay? By his eminent domain power. Okay? Because now it's going to be a matter of time before they force you out through what they call the encumbrances. All right? What they call taxes. All right? Taxes. When they give you a mortgage, you create an escrow account, and you create which is a trust account for the taxes, separate from what we call the mortgage account, which is an account created for the payment for the property which has not been conveyed to you, because on the escrow account, all the deeds are held by the stakeholder, which is that third party intervening. Continue. So the Jews in England, or the Ashkenazi Jews, first written record of them was in the account given by William the Conqueror in 1066. All right. We know they were expelled in 1290. All right. From England. Now they wind up in Scotland in the 18th century by way of what we call the Jewish diaspora. The Jewish diaspora brought them to England. Then they were expelled from England in 1290, and then they went to Scotland. Okay, they went to Scotland. It's going to the Ashkenazi. So, Ashkenazi Jew. Ashkenazi Jews constitute a Jewish diaspora population that emerged in the Holy Roman Empire around the end of the first millennia Christian era. Traditionally spoke Yiddish and largely migrated towards Northern and Eastern Europe during the Middle Ages due to persecution. So there you see the transition, the migration or the immigration from the Middle East, all right, what they call the Middle East, all right, to the Northern and Middle, Northern and Eastern Europe during the late Middle Ages due to persecution, all right? There you have it right there. To the Jewish diaspora, we know Jewish diaspora means a migration on the grim or immigrants to move from one place to another. Okay, so we know that from the Jewish diaspora, they migrated to England in 1066, and the migration happened to be with William the Conqueror. So from that, we can see that William the Conqueror must have been a Jew. Okay, William the Conqueror must have been a Jew. Well, it's good for you to watch this lesson so you can find out where you went wrong at, or the ancestors went wrong, because a lot of us are in a position as a result of not knowing where our ancestors went wrong. Okay, we know that William the Conqueror uh, upheld the laws of Edward the Confessor, and Edward the Confessor was the king of Wessex, while William the Conqueror was the king of Normandy. All right, but even through the invasion, he still honored the laws that were still in place. So it's our obligation as for the protection of the body of politics, that we all come to one remnant and one understanding about how things are supposed to be functioned. All right, and that was based upon the point marker that goes back to what we call about our perceived time immemorial, going back to time out of mind to where the story first started. Okay, we know the story was written by the Anglo Saxon, Berber, before William the Conqueror and the Jews called Ashkenazi Jews came into play. Okay? Because they got their own story, we got our own story. We don't want to intertwine or intermingle the same story. All right? Because this is where the confusion comes in. They traditionally spoke Yiddish and largely migrate toward Northern and Eastern Europe during the late Middle Ages due to persecution. So all Jews who are associated with the Jewish diaspora, all right, going back to what they said, the Holy Roman Empire, then the way to make clarity of what happened back in the Holy Empire with those who even speak Yiddish or any other language that you speak, you must understand the traditional immigration or migration or diaspora toward the northern and eastern Europe during the late Middle Age as a result of the persecution that you suffered. Okay? Very important. My coffee not warm enough. I apologize. Okay. So we know that the Jewish diaspora or the Ashkenazi Jews who migrated or immigrated as a result of the persecution are the same as the Ashkenazi Jews who migrated to England, and then when they were expelled from England in Hereford, where my first name comes from, they migrated to what we call Scotland in the 18th century. We can at least get that much from what's presented today here, as well as what's presented on my previous podcast. All right. So as we can see, the Ashkenazi Jews are the same as the Scottish Jews. All right. Both having a diaspora, an immigration or migration from an era going back to time immemorial, known as the Holy Roman Empire, all the way up to Northern Eastern Europe in the late Middle Ages, and still suffering from that same persecution. Okay? From the same persecution. All right? Let's go to the ethic of exposure. Ethic of exposure was a royal decree issued by Edward I, son of Henry II. All right? I mean, Henry III. Henry III, John, Richard I are all sons of Henry II. The son of Godfrey, the fifth kind of Anjou, the son of Hope, the ruler of Jerusalem, right? Where the Jews were expelled from, okay? Where the Jews were expelled from. They were expelled from Jerusalem through the Crusades. The Crusades were in, what was it? What was it? 1066 or 1099? 1099? Let's see. The Crusades. 1096. And the Crusades just didn't concern the expulsion of Jews, but Arabs as well. Okay? Arabs as well. You know, we had 9 crusades. All right. And we know Edward the First took place in the Ninth Crusade, and the Ninth Crusade was in Tripoli. I'm parts of in Tunisia. Okay. It was called Edward Longshank Crusade. All right. It took place in Tunisia. All right. We're talking about the first crusade. All right. And 1096 to 1099 was the first crusade of the series of religious wars or crusades initiated by the Latin Church in the Middle Ages. All right. This is the Roman Catholic church who initiated the crusade. Okay? And the first king of Jerusalem was Godfrey of Bouillon, the son of Eustace II, who was married to Gola of England, the daughter of Ethelred the Unready, the son of King Edgar the Peaceful, who is our Jesus Christ, who I am the reincarnation of. Right? So we see the Crusades took place in 1096, 1099. Back to Edict of Expulsion. On 18th of July 1290, what the Edict of Expulsion was a royal decree issued by Edward I and July 18th, 1290, expelling all Jews from the Kingdom of England. The first time a European state is known to have permanently banned their presence. Greetings, Countess Sister from the House of Search. Glad you can join us. She's online now, Countess Searching. She's way ahead of you. Yes. All right, well, I'm glad. Don't worry about the tardiness. It's all right with me. The Edict of Expulsion was a royal decree issued by Edward I on the 18th of July, 1290, expelling all Jews from the Kingdom of England. The first time a European state, you hear that, is known to have permanently banned the presence. Let's look at the source. Modern historian Cecil Ross notes that the significance of expulsion as a permanent act was fully appreciated by Jewish writers. All right, everybody needs to see that source. You can go to it. The date was mostly likely chosen as it was a Jewish holy day, the 9th of Av, commemorating the destruction of Jerusalem and other disasters that the Jewish people have experienced. Edward told the sheriff of all counties now, which also called Shire, that he wanted all Jews expelled before All Saints' Day, November 1st that year. Okay, so we can see we got the Jews from the Jewish diaspora going back to um, uh, the Roman Catholic Church, all right, and going back to when they were expelled from Jerusalem during Tigler of Fleiser, if I'm pronouncing his name right, in 733 BC. Okay, this is also the same time that the 22nd dynasty of Berbers are existing. Actually, Libyan Berbers from the Mesquite province called Libya, all right, are existing, which were invaded by the Assyrian Arabs, okay, or Babylonians, okay. They are all associated with uh, Shem, okay. The Jews of Japheth, which were from the, which some was Gomar, which Akhenaten descended out from, which is associated with Jur, okay. So you got Europe, which is Ashkenazi, you got Arabs, which is Shem, and you got Libyan Berbers, which is considered what we call which are called Berbers. Because we know on the other side of the you got the Mediterranean Sea, all right, which separated Europe from what we call North Africa, but then you have Egypt separated from what we call what they call that the Red Sea, the sea right there, and we know that Egypt are not the same as Berbers. All right, Berbers are more associated with North Africa on the northern coast of Africa, where the Egyptians or the Coptic Egyptians or the Arab Egyptians are associated with the other side of what we call I forgot that river. I forgot the name of that sea. Whatever the sea is. Y'all know what I'm talking about. Let me go back to 10. this, what's this? I forgot the name of this river. Right? So Africa, Egypt on this side of it right here. All right. This is associated with the Egyptian culture. Egyptian culture or the Coptic culture or the Greek culture are all associated with this part of what we call Asia. All right. Asia. Over here you have Europe. Okay. The T on map starts here. Boom, boom. All right. The letter T, let's go to T on map. Or what we call the Mapamunda. So we can get a global view of what we look at. All right. T on map. Or a circle of the land with the letter T inside and O. Also known as the Isidorian map, it's a type of early modern map that represents world geography. All right. So as we can see, we got the capital T and the lowercase t. All right. The capital T is symbolic of the T inside of the spirit. Okay. And we know, as you see, it says T and O map. And this is the Assyrian map at that. The first part represents Asia. This is that sea I was talking about between Egypt and one side of what they call the River Nile. The River Nile. Okay, yeah, the River Nile. I think that's it. The River Nile. Okay, this is the River Nile. This is hold on. This is the Mediterranean Sea. This is the River Nile. Okay, so it says Asia, Africa, and Europe. Europe is symbolic of, as we say, Japheth, whose son was Gomar, where the Ashkenazi Jews descended down from. Okay, Ham is actually Libya. Okay, Libya, which goes back to 22nd dynasty of the Libyan Berbers, starting with Shoshin the first. All right, which is known as Shishak in your Bible. And Shem is symbolic of Asia. It said a latter manuscript added names to the Noah's son, Shem, Japheth, and Canaan. For each of these continents, see biblical terminology for the race. All right, let's scroll down. This is the TNO map. We turn it clockwise. All this side will be Asia. This is the what we call the Mediterranean Sea. Okay, this is the Atlantic. All right, this is the Atlantic. This is the Nile. Okay, so all this on this side is considered part of what they call Asia. All this is over here associated with what they call Europe, and all this is associated with what they call Ham, which is actually Libya. Because if we go back to the evidence, the proof of the genetic DNA or mitochondrial DNA, it said that the Berbers were the founders of the Homo sapiens from North Africa and Europe. And it's a number by Asia, though. All right. And it's a number by Asia. So in order for that evidence, you have to go back to the watch all three the evidence of exposure. All right. We talk about that and I break down the map in its totality. All right. But as you can see here, we turn it clockwise. It's not dealing with the solar cross, which has four crosses in it. All right. It only has the higher case T. All right. Which deals with representing the three sons of Noah, Shem, Ham, and Japheth. All right. And we know that Ham was actually the Libyan Berbers, We know that Shem is the Asian. We know that Europe is dealing with the Ashkenazi Jews, and these are the ones who telling the story about Asia and about the African. Now, I think the Africans are in war. If there's any war going on in Africa, that's a result of the economic situation. But war pertaining to land is going on between who? The Arabs and the Jews. Okay, the Arabs and the Jews, which is the spear. All right, they're in their own spear. It's not happening over here. All right, you have migrants who immigrated over here from Jews as well as Arabs. All right, who are foreigners because they immigrated here. All right, so as a result of that, we must know our story because we know that in the Anglo spirit, it does not associate itself with the spirit that encompasses Europe, Africa, and Asia. Because the Anglo spirit is based off the English overseas possession. Okay, all the territories that we see now over in Europe, Africa, and Asia originated from what we call under the auspices of what we call Great Britain, United Kingdom. All right, because we know back under the English military reform, the movement was a cosmopolitan or universal movement. All right, but we're not talking about that universal movement back in that time because we're subject to a time and era with reference to what we call the Jews. Okay, that will put you in the era from the 11th century to the 19th century. Okay, from the 11th century to the 19th century. So if that's the case, then everything I'm presenting to you must be taken into consideration, right? Let's look at got the Chino map. Let's look at Libya, ancient Libya. Glad to have you too. Ancient Libya, ancient Libya. During the Iron Age, classical antiquity, Libya, from Greek, Esbon, Libye, which came from Berber, Libu, referred to modern day Africa west of the Nile River. It didn't say east of the Nile River, it said west of the Nile River. Greek and Roman geographer placed the dividing line between Ham and Cush. Did you hear that in the Holy Quran, Circle 7? The dividing line between Ham and Cush. All right. During the Iron Age, a classical antiquity, Libya, which came from Berber. So Libya came from Berber, not the other way around. Referred to modern day Africa west of the Nile River. Greek and Roman geographer placed the dividing line between Libya, Africa, and Asia of the Nile River, as I just said. All right. And then I even talking about Europe, which goes back to um, Jaspers, whose son was Gomar, where the Ashkenazi Jews descended down from. Okay, because we know that in the 1911 encyclopedia, let's just pull it up because I know from Mrs. Wright from the House of Wright didn't get to see that, so let's just pull that up for her real quick. 1911 Encyclopedia Britannica on the Berber. It didn't say Libyans, Libu, Tahamu, or any other name that somebody else want to refer to us. It said the Berber. Okay, it said the Berber. We know that the Berbers were ruling prior to 1066 because let's just prove it. Let me just read this first and I go to the counter after. All right, because once again we have a newcomer, we want to make sure that as our newcomers are on the same page as we are. You know what I'm saying? You know, her understanding is not there yet, but at least she'll be able to draw from whatever it is based upon the presentation that she is still on the same frequency. Okay. The fact that she realized the truth and getting in line with the truth shows that she's on the same frequency. All right. Because as I say, he who writes your books sets your timeline. Time never was when we were not. The life of time when we, the Anglo-Saxon brothers, begin, the time when the Anglo-Saxon brothers will be no more. Okay? So this is from a 1911 encyclopedia from 1798, created by the Encyclopedia Britannica Incorporated Company that was established in Edinburgh through the Scottish Enlightenment. Through the Scottish Enlightenment. You know, when you're enlightenment, we know that prior to being enlightenment, you were not enlightened. That means that you were at a state of non-enlightenment. This will mean the Dark Age. This pretty much was summed up in the Dred Scott case when he said if we turn our attentions towards slavery in the Dark Ages, it will be the white people who were enslaved. When Americans became Americans prior to them being called colonists, they took on the identity of white persons, contrast to those of being or referring to that of a genetic testing, as we see in verses, as we see in the case of Ahmad versus Ahmad Hassan, okay, as well as in what's the other case, Barat versus Barat thing. I forgot the case, but it actually referenced in the case, Enray Ahmad Hassan. Okay, everyone want to see that case in regards to how the Supreme Court distinguished the decipherment of the Naturalization Act of 1970 to those referring to only white persons, all right, in lieu of the citizenship and the protection of a citizen relative to the new founding government that were being established. Those who are not considered white persons under the protection of government when that Naturalization Act was being passed do not have any protection at law to this prior day, to this present day. And we know that because the only protection you do have is based off the 14th Amendment. And the 14th Amendment was originated after the Dred Scott case. Okay? We know the Dred Scott case, at that time, we were considered property. Okay? Property, a movable property. All right? We were a conveyable property. Very important for you to understand that. Well done, Countess Right. All right. Berbers names under which are included various branches of the indigenous living race of North Africa. Since the dawn of history, the Berbers had occupied tracts between the Mediterranean and the Sahara from Egypt to the Atlantic. So you see that? So when they distinguish the difference between uh, uh, the Berbers of Northeast Africa contrast to those above the Mediterranean Sea and those who are affiliated with that of the Asian side, because most Berber Asians are what they call Arab Berbers. Okay, they're called Arab Berbers. All right, or Berbers who are Arabs. All right. So it says that the origin of the name is doubtful. All right. I'm not going to read all this. Let's go. Thus, the true ethical name may become confused with Barbary, the designated naturally used by classical conquerors. Because we know the word barbarian is the term used for conqueror. Okay? Once again, the word barbarians are used for a name for conquerors. I was watching the movie the other day. What movie was that? before. To the Egyptians, they were known as Abiu, Masuasha, Kamahu, and Tehenu, and Kahaka, a long list of names which are found in Herodotus, and the Romans called them Numite, Gatalu, and Mori, terms which have been derived respectively from the Greek nomad, the name Guedola of Great Berber tribe, and the Hebrew Mahor of Western. Okay, now let's move a little further. I don't want to stay here too long. The megalithic monuments of Iberia and Southern Europe have their counterparts in Northern Africa, and it is suggested that these were all erected by the same race, or whatever name they are to be known. Berbers and Libyans in Africa, all right? Iberians in Spain, Celts, Gauls, and Picts in France and Britain, okay? So everybody had the name for the Berbers, all right? Berbers and Libyans in Africa, Iberians in Spain, Celts, Gauls, Picts in France and Britain, all right? So in spite of the history of foreign conquest, Phoenician, Greeks, Romans, Vandals, Arabs, and French, the Berbers physical type and the Berbers temperament and nationality have persisted since the Stone Age. Scottish Ashkenazi Jews have wrote this about the existence of the Berber tribes or Libyan tribes, which are the same people and known by different names on the continent of Asia and in the continent of Europe. Okay? This is what they're saying. We're not saying this. They're saying it. We're qualifying what they have preserved from time immemorial when it was out of our consciousness. All right? Out of our consciousness. The problem is that a lot of us don't want to take our mental body, our spiritual body, or our etherical body into that time and era where the physical body cannot go. Because they assume that those people who lived back there in that time and era based upon the physical body didn't look like us based upon the color of a skin. All right? A color of a skin. Well, we know that type of depiction based upon affiliation with a person was created in the 19th century. The 18th century. All right? Through the Naturalization Act of 1790. Everybody hold that thought. So it says that the Berbers' nationality have existed since the Stone Age. So we know that the nationality of the Berbers had existed since the Stone Age, and we know that the word Africa was called noble stone. We know that Jacob fell asleep on a stone. All right, it's called Jacob stone. We know that Jacob stone denotes to the dream that Jacob had in regards to the estate that was promised from his father Abraham, which from where we get the story Jacob's ladder. And when you talk about the story, angels were ascending up and down the ladder. Okay, up and down the ladder. Okay, we understand that the people more associated with that abstract story who brought the concrete are affiliated with British Israelism because that denotes to what we call the Jacob Stone or the Scone of Abbey. Okay, anybody ever heard the Scone of Abbey? The Jacob Stone or the Scone of Abbey is the ceremonial stone for which all kings of Scottish kings took their coronation. This stone was taken from the Scottish kings by Edward I, and it was a part of the coronation chair of Edward the Confessor, a king of Wessex, which is still used in the coronation ceremonies on the United States, on the United Kingdom coronation ceremonial for the king of what we call the United Kingdom. Okay, so the story is thick. It has many trap doors. It has many tunnels, and we're going to go and inspect every one of them. Okay, let's continue. The invaders who have mostly affected the Berber race are Arabs, but the two races with a common religion, often a common government with the same tribal grouping, having failed to amalgamate to any great extent. This, in fact, has been emphasized by Dr. R.G. Latham, who writes, all that is not Arabic in the Kingdom of Morocco, all that is not Arabic in French provinces of Algeria, all that is not Arabic in Tunis, Tripoli, and Fez is Berber. All right. So that means that the Arab took over Berber territory, which is associated with Northeast Africa, what they call Libya. Okay. Versus the Arabs who family or descent originated in what they call Asia. Okay. Very important you understand that contrast to those who family took place in Europe. Because we know that Europe, Asia, all refer to the Berbers by different names. That means that we were in all those three places. All right. Not the same people, but we were all in those three places. Yes. Yes, you're right. Under the chair, or ever to confess. The explanation lies in the profound distinct of character. The Arab is a herdsman and a nomad. The Berber is an agriculturist and townsman. The Arab has been built his social structure on the Quran, which inculcates absolutism, aristocracy, theocracy. The Berber, despite his nominal Mohammedanism, is a Democrat with his Jimna, which they want to call it, and we call it Witteman or Witten, which means wise counsel, which goes back to not just Alfred the Great, but his predecessors and his ancestors. Okay, Britamont and Canun was the unwritten code of the Magna Carta of the individual liberties as opposed to the community good. It said the unwritten code of Magna Carta. You didn't get the written code of Magna Carta till 1215 when you get to what we call the barons of Exchequer, which were judges who enrolled against John as a result of the conflict that originated from what we call the anarchy. Yes, the anarchy, a breakdown in the civil government of England. The advertising of the Berbers is indeed limited to little beyond conversion of the latter to Islam. You know, King Edgar the Peaceful was called the King of Peace, all right, or the King of Islam, all right. He represented that meaning of peace because when he ruled, there were no wars, okay. The Arab transported to the soil, which does not always suit him. That means he constantly moves. So far from thriving tends to disappear, whereas the Berber becomes more and more aggressive and yearly increases in numbers. At present, he forms at least 3/5 of the population. In Algeria and in Morocco, the proportion is greater. All right. The difference between the Berber and the Arab of the Barbary state is that word Barbary or Barbary, which is a name as he stated, is more familiar with conquering. It is summed up by Dr. Randall McIver in the following words. The Berber gives the impression of being as he is, the descendant of men who has lived in sturdy independence, self-governance, and self-reliance. Another word for that is peace. The Arab is a degenerate offspring of a race which only from its history and past record can claim any title of respect. Cringling, venal, avariciousness, and dishonest. The Arab combines all the faults of a vicious nature with those which a degraded religion inculcates and encourages. The Berber, on the other hand, is straightforward, honest, by no means averse to money making, but not unscrupulous in the method which he employs to this end. intelligent in degree to which the ordinary Arab never approaches, and trustworthy as no Arab can be. Okay, so now this is what the Encyclopedia Britannica of 1768, which originated from the Encyclo 1911, Encyclo Britannica Incorporated Company that was established in Edinburgh, which is in Scotland, where the Jews immigrated or migrated to by way of the diaspora from England in the 10th century. In the 13th century, 1290. Because we know when they came to England in the 11th century, i.e., 1066, William the Conqueror, that originated from the Jewish diaspora that originated in the territories in which we speak of right now. Okay, we're speaking about now, and that goes back to Rome. Okay, Rome, the Roman Empire. Roman Empire was separated from the English Empire through one wall called the London Wall. Because the cities of London, i.e., Roman London, was called Londinium, and the city of Anglo-Saxon London was called Londonwick. Okay, we already talked about that. Unfortunately, I don't have time to continue to go back and reiterate that and to test that again. But those who want to validate it, you have to continue to watch the previous lectures that I have posted prior to this one. Okay. So we see that apparently that the Anglo-Saxon English government and the quote unquote law of the Magna Carta is not associated with the William the Conqueror, which started the English renown year. It is associated with the Berber calendar, with the Berber renown year, going all the way back to the Anglo-Saxon kings of Wessex, as well as those of French descended from the Plantagenet king. Okay, let's get it. I'm doing a lot of communication on the side. I hope y'all paying attention. I'm playing with you. All right, here. Okay. So now the Ashkenazi Jews, the Ashkenazi Jews are the ones who came to the Jewish diaspora through those who broke away from the Holy Roman Empire. Okay. The Holy Roman Empire, let's just view that a second before I go forward. Ashkenazi Jews. All right. The Ashkenazi Jews constitute a Jewish diaspora population that emerged in the Holy Roman Empire. We also let the Ashkenazi Jews who migrated or immigrated as a result of the emergence in the part itself. We know the Ashkenazi Jews, which are the Scottish Jews, are constitute the Jewish diaspora and the Scottish diaspora. It goes all the way back to the Holy Roman Empire, okay, around the first millennia CE. Here's your source, all those who want it. Nationalism and economic development in modern Eurasia, okay? Okay, so the Ashkenazi Jews, all right? Then they started, let's go back to the Scottish Jews, right? Back to Scottish Jews, a history of the Jews in Scotland, right? History of the Jews in Scotland. Reading the Archbishop member from the House of Belmont. Good to have you here today. Scottish diaspora. Let me just pull that up. Scottish diaspora. Scottish diaspora. The Scottish diaspora consists of Scottish people who immigrated from Scotland and their descendants. The diaspora is concentrated in the countries such as the United States, Canada, Australia, England, New Zealand, Ireland, to the lesser extent, Argentina, Chile, and Brazil. So we're talking about after the Jewish diaspora was led to their immigration or migration to England in 1066, was led to an expulsion from England in 1295, but led to the immigration and migration to Scotland, all right, which then they received their enlightenment, all right, through the Scottish Enlightenment, which was verified through the 1911 Encyclopedia of Britannica. And when this enlightenment came, they took this enlightenment around the world, all right? They took the Scottish Enlightenment around the world. And this is what they call the Scottish diaspora. The Scottish diaspora consists of the Scottish people who immigrated from Scotland and their descendants. So they left Scotland now. Okay? They left Scotland. All right, that's how we're going to read on that part right there. So if they left Scotland, where did they go? That's a key point. Where did they go when they left Scotland? Let's see. We want to associate the Jews with America. We already associated with what we call Africa, Europe, and Asia. All right, we see the history concerning them today. All right, they're in a state of war. All right, they're in a state of war. The Arabs and the Jews are in a state of war, and they're fighting over land. Okay, they're fighting over land. Okay, we already see who preserved the land as from the records of Exchequer, which means the current record. Okay, and we know the Exchequer of the Jews were the ones who kept the current record. Okay, and the only one who fit that category are the Scottish Jews. Why? Because out of all the Jews who claim to be Jews, these Jews were sitting there or being ruling as minor at this particular time. All right. We see what's going on. The American Jews or the Jewish Americans are the American citizens who are Jewish. All right. Whether by culture, ethnicity, or religion. According to the 2020 poll conducted by Pew Research, approximately 2/3 of American Jews identify as Ashkenazi, Ashkenazi Jews. 3% identify as Sephardic, and 1% identify as Mizrahi. An additional 6% identify as some combination of the three categories. Okay? Whatever group you're a part of is irrelevant. We're looking at it from a whole, from the history. All right? Very closely. Look, y'all. Please look. Jews were present in the 13 colonies since the mid 17th century. All right? This during the Scottish diaspora. Okay? Through the Scottish diaspora as a result of the Scottish Enlightenment. All right. Prior to that, they had no enlightenment as a result of their expulsion, all right, from England as well as Jerusalem. Okay. Jews were present in the 13 colonies since the mid-17th century. However, they were in small numbers, with at most 200 to 300 having arrived by the 1700s. Those early arrivals were mostly Sephardic Jews, immigrants of Western Sephardic, also known as Spanish and Portuguese Jews. All right, so now you're talking into the Spanish Jews. The Spanish are going into that category. That goes back into Asia. Okay? Asia. But by the 1720s, Ashkenazi Jews from the diaspora communities in Central and Europe, Asia predominated. Did y'all hear that? What are you talking about? Y'all see that? By the 1720s, Ashkenazi Jews from not the Scottish diaspora, but from the Jewish diaspora communities in Central and Eastern Europe predominated. They're talking about over here, y'all. Do you see that? Over here. Here. This out now. Ulster's Scots people. This is dealing with Ireland and Scotland. Okay? This is associating Ireland with Scotland, which are some of this from the same group, from the same nation, from the same culture. All right. The Ulster Scots, also called Ulster Scots people, or in North America, Scottish Irish or Scottish Irish are an ethnic group in Ireland who share a common history, culture, and ancestry. Some speak Ulster Scot dialect of Scot languages, a Western Germanic language, as the ethnicity. They descend largely from Scottish and English settlers who moved to the north of Ireland during the 17th century. They say English, they ain't talking about Anglo-Saxon British. They're talking about Jewish Scottish descendants, i.e., Scottish Jews. All right, you see it right there. Scottish Irish. Move down. The Ulster Scots migrated to Ireland in large numbers, both as a result of a government-sanctioned plantation of Ulster, a planned process of colonization, which took place under the auspices of King James VI of Scotland and soon to be the first king of England, on land confiscated from members of the Gaelic nobility of Ireland who fled Ulster as part of a larger migration or unplanned wave of settlement. Ulster Scot people immigrated from Ireland in significant numbers to the American colonies, later the United States and elsewhere in the British Empire. Scottish Irish is a traditional term for Ulster Scots who immigrated to America. So it was a planned process of colonization, okay, under King James VI of Scotland and the First King of England. A planned process of colonization, not just make a reference to uh, 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 Scottish Jews or Spanish Jews and all the other Jews that are associated with the term of the name Jew. All right. It was a planned process of colonization to this place now called North America. North America. All right. It's very important because King James established the colonies over here, what they call North America. Ulster Scots people immigrated from Ireland in significant numbers to American colonies, later the United States and elsewhere, and the British Empire. They didn't say the English Empire, because they were expelled from the English Empire. All right, until the British Empire took back over to what we call the Battle of Dunbar in 1650. All right, which the Jews were allowed to come back into England when it fell under the British rule. All right, prior to that, they were expelled through the Battle of Dunbar of 1296 under Edward I. All right. A lot of us don't know about this history, but you're going to know about it now. All right. And that started what we call the planned process of colonization. Okay. For the Scottish and Irish descendants who descended down from the Jewish diaspora, going all the way back to the Roman Empire. Okay. We must understand this story in its entirety. Okay, before we go into the planned process of colonization over here to North America, as well as the Americas, as well as all around the world, where our ancestors helped build the Homo sapien ancestry, which are the human beings. All right, we're talking about here first. All right, so let's get there. Battle of Dunbar. Real quick. Battle of Dunbar. Real quick, y'all. The Battle of Dunbar was the only significant field action of campaign of 1296 during the beginning of the First War of Scottish Independence. Okay? Scottish Independence. Let's see if we can get a narrative. Now look at this. The First War of Scottish Independence was the first of series of wars between English and Scottish forces. It lasted from the English invasion of Scotland in 1296 until the de jure restoration of Scottish independence with the Treaty of Edinburgh, Northampton in 1328. De facto independence was established in 1314. How could it be a de jure king if de facto independence was established in 1314 at the Battle of Bannockburn? Bannockburn. The wars were caused by an attempt of English kings to establish their authority over Scotland, while Scots fought to keep English rule and authority out of Scotland. Okay, the term War of Independence did not exist at that time. Listen, y'all. The term War of Independence did not exist at that time. The war was given that name retrospectively many centuries later after the American War of Independence made the term popular and after the rise of modern Scottish nationalism. Okay? Around the same era, y'all. Around the same era. So the Battle of Dunbar was a result of the First War of Scottish independence. All right? The background of the Battle of Dunbar. King Edward I of England had invaded Scotland in March 1296 to punish King Bailey, John Balliol for his refusal to support English military action in France. After the sack of Berwick upon Tweed, Edward was to complete the conquest of Scotland, remaining in the town for a month, supervising and strengthening of its defense. On 5th of April, he received a message from King John renouncing his homage to which he remarked of a foolish name. What a folly he commits if he will not come to us, we'll go to him. All right. So this is the Battle of Dunbar, the first battle of independence. All right. And we know that this Battle of Dunbar eventually led to the expulsion of the Jews in England in 1295. Okay. 1295. Battle of Dunbar. Let's go here. Battle of Dunbar, 1650. Battle of Dunbar, 1650. Battle of Dunbar was fought between the English New Model under Oliver Cromwell and a Scottish army commanded by David Leslie on the 3rd of September 1650 near the Dunbar of Scotland. The battle resulted in the decisive victory for the English. And they're not English, all right? Everybody doing stuff under the name of the English when they're not English. So this is the reason why we opt out for the name English and go to Anglo-Saxon versions, okay? Even though we speak English and we have the culture um, that is associated with the English, we know English pertaining to the Anglo, all right? And we know Anglo is a synonymous with the word Anglo, which is associated with what we call the Anglosphere. And when we're talking about the Battle of Dunbar, it says right here, it was the first major battle of 1650 invasion of Scotland, which was triggered by Scotland's acceptance of Charles II as King of Britain after the beheading of his father Charles I on the 30th of January 1649. All this is under what y'all call a republic, which they call the English Commonwealth, okay? Under what they call a rump parliament. A rump parliament. So we see this battle that's going on between 1296 and 1650 took place on what we call overseas possession of English governance under what we call radical title of the English king. Very important to understand because they're talking about littoral rights. You have what they call riparian rights and littoral rights. All right. I don't know if any of y'all ever heard of these terms, but they will be discussed today in regard to the overseas possession of English territory that go back to Atherton of 927. Okay, so we see that the Battle of Dunbar from 1296 in regard to the independence of Scotland, which resulted from their expulsion from England in 1295, their reconciliation of the Jews who were expelled, i.e. the Ashkenazi Jews that were expelled, happened under Oliver Cromwell through the English Civil War under what they call a rump parliament under Republican Commonwealth. Okay, a Republican Commonwealth. When you're done with the Commonwealth, that means that all the land that was entailed under the crown has been under the auspices or under the something what they call bona vacantia under the crown. And the crown represents the holder of the property if there is no king. Okay? So what you functioning now under what they call a republic is nothing more than a commonwealth under a rump parliament, which you call the United States Congress. Okay? The United States Congress. Because we know Dred Scott case said slavery was brought into the colonies by what? By who? By Great Britain. It said that. It is. But we know that the Ulster of Scots, which is just a family of the Irish in Scotland, affiliated, affiliated together, are in union through what they call the Treaty of Union of 1707. Okay? The Treaty of Union of 1707, all right, which was Ireland and Scotland, which are those to the Ulster Scots, Scottish people, which is affiliation between the Scottish people and the Irish people under a planned process of colonization, which is a diaspora, all right, or immigration or migration from a place, from one place to another, all right? If you're leaving your home to go somewhere else, that means that you were forced on what they call acquisition or prescription, or we call right of conquest. All right. If you're being left because you were allowed to come there and you didn't live up to uh, uh, the encumbrances that you were subject to based off your allowance to come there, then you have the right to be expelled. Okay? That's what citizenship is all about. If you don't live up to a citizen, you lose your citizenship. Okay? You lose your citizenship. So the Irish and the Scottish, which automatically be associated with the Scottish Jews or the Ashkenazi Jews who migrated under what they call the Jewish diaspora, going all the way back to what they call uh, Rome, okay? Because it said when we dealt with the Ulster Scots, that was associated with the diaspora. Let's just go back there real quick. Ulster Scots. What did I say? What did I see? We see that the Irish and Scottish Jews are associated with the what was it? The Ireland and Scotland associated with Scots, Ulster Scots, which are pretty much the same people who participated in a planned process of colonization, immigrating from one place to another. Okay, we see that here as expressed in Ulsters of Scots. All right, now let's go to this planned process of colonization. All right, because we know colonization is nothing more than what they call a diaspora. Okay, I've seen that word somewhere in, but where did I see it? Hello, Dunbar, was it there? I hate it. Okay, Ulster Scots is a planned process, all right, of colonization under the auspices of King James VI of Scotland and the soon to be the first king of England. He was no first king of England, y'all. All right, he was no first king of England. All right, let's go to the planned process of colonization and to see where this process of colonization and the plan for the process of colonization took its root. Okay, took its root because it said Ulster Scottish people immigrated from Ireland in significant numbers to the American colonies, later the United States and elsewhere in the British Empire. Scottish Irish or Scot Irish is a traditional term for Ulster Scots who immigrated to America. Right, so let's go to the planned process of colonization. This is where you get to plantation settlement of colonies. Yes, the first king named James, okay, de facto, as Archbishop said. Plantation settlement or colony, all right? In history of colonization, a plantation was a form of colonization in which settlers would establish permanent or semi-permanent colonial settlement in a new region, all right? Whether it was by way of a charter or a deed, or whether it was by immigration, which is based upon right of conquest, all right, eminent domain, our birth possession, all right, whatever means, it all falls under colonization, okay? The term first appeared in 1580s in the English language. The term first appeared in 1580 in the English language to describe the process of colonization before being also used to refer to a colony by the 1610. By the 1710, the word was also being used to describe large farms where cash crop goods were produced, typically in tropical regions, right? The first plantation that was established during the first plantation were established during the Edwardian conquest of Wales. Did you hear that? The first plantation was established during the Edwardian conquest of Wales and the plantation of Ireland by the English crown. In Wales, King Edward I of England began a policy of constructing a chain of fortifications and castles in northern Wales to control the native Welsh population. The Welsh were only permitted to enter the fortification and castles unarmed during the day and were forbidden from trading. In Ireland, during the Tudor and Stuart era, the English crown initiated a large-scale colonization of Ireland, and particularly the province of Ulster, with Protestant settlers from Great Britain. These plantations led to the demography of Ireland becoming permanently altered, creating a new Protestant ascendancy which would dominate Irish society for the next few centuries. So once again, I'll repeat. The first plantations were established during the Edward conquest of Wales, and the plantations of Ireland by the English crown. In Wales, King Edward I of England began a policy of constructing a chain of fortifications and castles in northern Wales to control the native Welsh population. The Welsh were only permitted to enter into the fortification and castles unarmed during the days and were forbidden from trading. In Ireland, during the Tudors and Stuart era, Tudors dealt with the house Henry VII, Henry VIII, Queen Elizabeth I, who passed the torch to King James the First, all right, Sixth of Scotland and the First of England, as Archbishop said, as de facto, because he was just named James, the first king of England. All right. The English crown initiated a large-scale colonization of Ireland, in particular to the province of Ulster, with Protestant settlers from Great Britain. So there we see it right there. So this colonization process was actually established by the Edwardian conquest of Wales. How much do we know about that? How much do we know about that? Let's see. Right? Norman conquest of Wales. The Norman invasion of Wales began shortly after the Norman conquest of England under William the Conqueror, who believed England to be his birthright. Initially in 1067 to 1081, the invasion of Wales was not undertaken with a fervor or purpose of the invasion of England. However, a much stronger Norman invasion began in 1081. By 1094, much of Wales was under the control of William's son, the heir later King William II. The Welsh greatly disliked the gratuitously cruel Normans, and by 1101, he regained control of the greater part of their country under the long reign of King Rupert ap Sinan, who'd been imprisoned by the Normans for 12 years before his escape. So now we see a Norman invasion of Wales under Edward I, when it was actually done prior to Edward I by William the Conqueror until 1067. Okay? Do everyone want to see that? Do everyone see that? We're going to go back to plantation of settlement. Go back there real quick. Now look how far we're talking about the territorial rights and representative rights now. I'll go into that in a second once I break this down. The first plantations were established during Edward the First conquest of Wales and the plantations of Ireland by the English crown. It didn't say the Scottish crown. It didn't say the Ireland crown. It said the English crown. Very important. In Wales, King Edward the First of England began a policy constructing a chain of fortifications and castles, these are called forts, in North Wales, and control to the native population. We already read to that. All right, let's go. It says, it said, where is that? It says, in Ireland, during the Tudor and Stuart era, the English crown initiated a large-scale colonization of Ireland, and Ireland during the in Ireland, I'm reading too fast. In Ireland, during the Tudor and Stuart era, the English crown initiated a large-scale colonization of Ireland, and particularly the province of Ulster, with Protestant settlers from Great Britain. These plantations led to the demography of Ireland, becoming permanently altered, creating a new Protestant ascendancy which would dominate Irish society for the next few centuries. In North America, during the period of European colonization and modern period, several plantations were established by English settlers, including Virginia, Rhode Island, and elsewhere throughout the 13 colonies. Other European colonial powers used the plantation method of colonization as well, though not to the extent of English settlers. Once again, they're using that word English settler in regards to William the Conqueror, and because we know William the Conqueror was the first one to invade England and was the first one to invade Wales. Okay, and we know William the Conqueror was living based off the virtues that existed prior to him, which was the rules governing the Anglo-Saxon Bourbons. All right, because they were Anglo-Saxon Bourbons king before William the Conqueror became the first English-speaking Algier king. Okay, and everything that they did based off colonization was brought over to North America as established by the planned colonization, which they call it here, the settlement, which we call settlement or colony, okay, which they call settlement or colony. Let's go back to the plantation. Yeah, plantation. So we're here now. Okay. So Norman invasion of Wales. Let's go back there. But prior to the plantation settlement or colonies established by the Edwardian conquest of Wales, because they said the Edwardian conquest of Wales. Prior to that conquest of Wales, you had a Norman conquest of Wales by William the Conqueror, which we read here. Norman invasion of Wales, right? The Norman invasion of Wales began shortly after the Norman conquest of England under William the Conqueror, who believed England was his birthright. All right, in a nutshell. Let's go back to the Norman conquest. He also took place in that. Norman conquest of Norman conquest of the Norman conquest or the conquest was 11th century invasion of occupation of England by an army made up of thousands of Norman, French, Flemish, Briton troops, all led by Duke of Normandy, later styled William of Conquer. So we see William the Conqueror was the one who not just invaded England, he invaded Wales. Okay, we know that Jews came into England with William the Conqueror, who invaded England and Wales. We know that Edward the First came to rule after William the Conqueror in 1290, around 1290, 1296. We know that the Jews were expelled from England, right, by William the Conqueror, right, which established the Edwardian, which said the Edwardian conquest of Wales after William the Conqueror did it. Let's just go back there. right there, Edward conquest of Wales. All right. So Edward's conquest of Wales came after the Norman conquest of Wales. It came after the Norman conquest. We know that the Norman conquest of Wales and the Edwardian conquest of Wales came as a result of the conflict with the Scottish Jews or the Ashkenazi Jews who originated from the Jewish diaspora going all the way back to Great Rome. And then from the Scottish Jews or the Ashkenazi Jews came the affiliation with the Ulster and Scottish Jews, which originated in your Protestant, who now became or immigrated as settlers from Great Britain. We know Great Britain only came about through the Treaty of Union of 1707. And as a result of that, those immigrants migrated to what we call North America, okay? To what we call the 13 colonies. Brother? So yes. Referendum water rights, okay? Referendum water rights. Referendum water rights, or simply referendum rights, is a system for allocating water among those who possess land along its path, okay? It has its origin in English common law. Referendum water rights exist in many jurisdictions with a common law heritage, such as Canada, Australia, New Zealand, and the states in the eastern United States, okay? All associated with property, y'all. Common land ownership can be organized into a partition unit. A corporation consists of a landowners on the shores that formerly owns the water area and determine its use. Okay, I'll read it again. Common land ownership can be organized into a partition unit. All right, an aggregate unit, i.e., a corporation aggregate, consisting of landowners on the shore that formerly owns the water area and determines its use. This is based on either referendum rights or littoral rights. Okay. Under referendum principles, all landowners whose properties adjoin a body of water have the right to make reasonable use of it as it flows through or over their property. If there is not enough water to satisfy all users, allotments are generally fixed in proportion to frontage on the water source. These rights cannot be sold or transferred other than with the adjoining land and only in reasonable quantities associated with that land. The water cannot be transferred out of the watershed without due consideration as to the rights of the downstream referent landowners. This all concerning high tide, what's it called high tide, not high tide, what's it called? Talked about it earlier. Yeah, high water mark, low water mark. Okay, high water mark, low water mark. Okay, well now we're talking about referendum rights. All right, contrast to what we call littoral rights. All right, meaning those who have access to the water rights. Okay, who has a right to that natural resource. All right. In England, environmental agencies to weapon rights and duties in England and in Wales. We're talking about England and Wales. They came up under the jurisdiction of Edward the First. All right. Prior to William the Conqueror's invasion of England and Wales, that authority and the jurisdiction all fell back under Edward the First. All right. Son of Henry the Third, son of Henry the Second, son of Godfrey the Fifth, Count of Anjou, son of Fulk, ruler of Jerusalem. The rights include ownership of the land up to the center of the water course unless it is known to be owned by someone else. The right for water to flow onto land in its natural quantity and quality, the right to protect property from flooding and land from erosion, subject to approval by the agency, the right to fish in the water course unless the right is sold or leased if its angler has a valid environmental agency rod license. They are all include the right to acquire a question and the right to boomage, a fee charge for security boom, generally for retention of law. This is all what we call encumbrances. Okay? Encumbrances and what they call easements. All right? Easement. Duties on the flows of water without obstruction, pollution, or diversion affecting the rights of others. Maintain the bed and banks of the watercourse to clear any debris, whether natural or artificial. To keep and convert rubber screens, weirs, and mill gates clear of debris. Be responsible for protection of land from flooding and cause no obstructions, temporary or permanent, preventing the free passage of fish, except flood flows, even in caused by inadequate capacity of downstream, but there is no duty to improve the drainage capacity of the water course. This is all protected under what we call public land or public domain. Okay, it all belongs to the public. All right, and under the public, it's called a commonwealth. Under the king, it's part of what we call the king's radical title. Okay, let's prove it. United States. Under reverend laws, water is a public good like the air, sunlight, or wildlife. It is not owned by the government, state, or private individual, but is rather included as part of the land over which it falls from the sky or the travels or then travels along the surface. All right. In determining the contours of referendum rights, there is a clear distinction between navigable public waters and non-navigable waters. The land below navigable waters is the property of the state and subject to all the public land laws and most states' public trust right, i.e. the escrow account, all right? Public trust, all right? This is called public lands or what we call crown land. Navigable waters are treated as public highways with an exclusive referendum right ending at the ordinary high water mark. I already talked about that. You got the high water mark and low water mark. High water mark and low water mark. Like a road, any referendum right is subordinate to the public right to travel on the river, but any public right is subject to the nuisance laws and the police powers of the state. Eminent domain power, y'all. It is not an individual right or liberty interest because a finding of navigatability establishes state versus federal property. Navigatability for purposes of riverbed title is a federal question determined under federal law. The states retain the power of defining the scope of the public trust of a navigable river. A non-navigable stream is synonymous with a private property or joint owned property if it serves as a boundary. Okay? This is how they determine property through what we call boundaries and fixtures. Okay? All right, so this is referendum rights. All right, let's go to littoral rights. Littoral rights. In United States law, littoral rights are rights concerning properties that abut static water like an ocean, bay, delta, sea, or lake, rather than a flowing river of a stream called riverine. All right. Littoral rights are usually concerned with the use and enjoyment of the shore, but also may include rights to use the water similar to riparian rights. Okay. So riparian refers to like streams. Littoral rights refer to like big bodies of water, seas, oceans. All right. That's what it refers to. All right. Now let me give you a diagram so it will make it more simple for you to understand. And this is from a real estate book. Riparian rights. Right. Lot A, lot B. If lot A and lot B, which is separate, which is called boundaries, based off the description of the interest of the estate that you have, if it's separated by a referendum, then there are statutes that determine the rights of the owner in regards to the property associated around what we call non-navigatable streams, subject to referendum laws. Okay, dealing with high water mark and low water mark. Okay, contrast to that of what we call littoral rights, dealing with law bodies of water such as oceans, seas, etc. And as we see that the waters itself are owned by the public. Okay, they are owned by the public. Littoral right. All right, lot A, meaning high water mark versus low water mark, is owned by the public. Okay, is owned by the public. All right. So here you have littoral rights and referendum rights and the difference between them both. All right. One concerning a stream or a small body of water in regards to proving who has a right to the interest of that stream concerning uh, 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 everything associated with the stream, whether it's mineral rights, uh, uh, water rights, air rights, etc. All right, all these things are governed by what they call laws governing the environment. All right, which is something to what we call a public trust, or what the public call the public trust doctrine. Okay, so let's continue. This brings up radical title. Radical title is a concept of English common law that refers to the crown underlying title to all lands held in the overseas plantation and colony. Did you hear that? Once again, radical title is a concept in English common law, not Scottish, not Ireland, not Jewish, not Arab, not Muslim, but English common law that refers to the crown's underlying title to all land held by overseas plantations and colonies. It grants the crown the power to alienate others from land and to transfer beneficial owner of the land to itself or others but it does not grant beneficial ownership. Did you hear that, y'all? Title to overseas possessions. What are the overseas possessions? The English overseas possessions, also known as English colonial empire, remember the plantations of the settlement or colonies was established through the Edwardian conquest of Wales. All right. He already had jurisdiction in England because they were expelled in England. All right. In 1290, the expulsion of the Jews in Wales as well as the plantation of colonies and Wales was established by Edward I. All right, due to what we call Edward's conquest of Wales, which was preceded by Norman invasion of Wales and Norman invasion of England. All right, which automatically came up under the jurisdiction of the Plantagenet kings through Godfrey V Count of Anjou, marriage to Empress Matilda, through what we call the anarchy. Okay, the anarchy, which was a result of what we call Henry I's sons dying in what we call the White Ship, which left uh, uh, a break and the unification of both kingdoms, okay, between France and England. So we know that France is under jurisdiction of the Plantagenet king through Godfrey V Count of Anjou, son of Fulk, ruler of Jerusalem, and Edward the Confessor's descendant was a Margaret of Scotland. Margaret of Scotland was the mother of Matilda of Scotland, who married Henry I, son of William the Conqueror. Okay, so it was Margaret of Scotland's granddaughter, Empress Matilda, who married Fulk's son Godfrey V Count of Anjou, which aligned the kings of Wessex and the kings of France, i.e., the Counts of Anjou. Okay, which automatically ruled the Plantagenet crown and created the cadet branches of the Yorks and the Lancasters, and which Edward I was the founder of. All right, Edward I was the son of Henry III. Edward I was the father of Edward II, and Edward II was the father of Edward III. Edward III was the father of John Gaunt, and John Gaunt promulgated the de facto rulers, which started with Henry VII from the House of Tudors by way of what we call taking over the Lancaster branch as the cadet branch of the Plantagenet crown. Okay, these are all facts. So the English overseas possession, also known as the English colonial empire, and when you're dealing with the English colonial empire, you have to go back to the Edward I, what we call Edward I's conquest of Wales. All right, Edward I's conquest of Wales, called the Edwardian conquest of Edward I. All right. The English overseas possession, also known as the English colonial empire, not British Empire, the English Empire, not British American Empire, but the English Empire comprised a variety of overseas territories that were colonized, conquered, or otherwise acquired by the former kingdoms of England during the centuries before the Act of Union of 1707. So we already had jurisdiction over the territories called English overseas possessions, i.e. colonies or settlements, prior to the unification of the Act of Union of 1707 between the Kingdom of England and the Kingdom of Scotland, now called the Kingdom of Great Britain. Okay? These are facts. The many English possessions then became the foundation of the British Empire, not the English overseas possession, but now the British overseas possession, and a fast-growing naval and mercantile power, which until they had yet to overtake those of the Dutch Republic, the Kingdom of Portugal, and the Crown of Castile. All right? The first English overseas settlement was established in Ireland, i.e. Ulster, Scotland affiliated together, followed by other North American, Bermuda, and West Indies by trading posts called factories through what we call the industrial age, and East Indians such as Batam and the Indian subcontinent, beginning with Surat. In 1639, a series of English fortresses of Indian coast was initiated with Fort St. George. In 1661, the marriage of King Charles II to Catherine of Braganza brought him at part of her dowry new possessions which until then had been Portuguese, including Tangier in North Africa and Bombay in India. Okay. In North America, Newfoundland and Virginia were first centers of English colonization, not British colonization, not Irish colonization, not Scottish, Arab or Jewish. Did you hear that? It says North America, Newfoundland, and Virginia were first centers of English colonization during the 17th century. Maine, Plymouth, New Hampshire, Salem, Massachusetts Bay, New Scotland, Connecticut, New Haven, Maryland, Rhode Island, and the province were settled. In 1664, New Netherland and New Sweden were taken from Dutch, becoming New York, New Jersey, and part of the Delaware and Pennsylvania. Okay? But the origin all goes back to what? The Kingdom of England, and generally dated from the rule of Ashton from 927. During the role of the House of Nintlinga from 1030 to 1014 and to 1016 to 1042. England was part of a personal union that included the domains of Scandinavia. In 1066, William the Conqueror, Duke of Normandy, conquered England along with the Ashkenazi Jews from the Jewish diaspora, and then through the Scottish Enlightenment and the Scottish diaspora spread to what we call North America into this present day. In 1066, William the Conqueror, Duke of Normandy, conquered England, making the Duchess a crown land of the English throne, not the Frankish throne, not the Danish throne, not the Frankish throne, not the Nordic throne, but the English throne. Though the remainder of the Middle Ages, the King of England held extensive territories in France based on their history in this duchy. Under the Angevin Empire, England formed part of a collection of lands in the British Isles in France held by the Plantagenet dynasty. The collapse of this dynasty led to the 100-Year War between England and France at the outset of the War of the King of England, who ruled almost all of France. You hear that? Europe. But by the end of the 1453, only the Pale of Calais remained to them. Calais was eventually lost to the French in 1558. Channel Island, as a remnant of the Dutch of Normandy, retained their link to the crown to this present day. Okay? These are facts, y'all. Facts. Okay. The voyages of Christopher Columbus began in 1492, and his sight landed on West Indies on the 12th of October that year. In 1496, excited by the successes in overseas exploration of the Portuguese and Spanish, King Henry VII of England commissioned John Cap, the leader boys, to find a route from the Atlantic to the Spice Islands of Asia, subsequently known as the Search for the Northwest Passage. Cap sailed in 1497, successfully making landfall on the coast of Newfoundland. There, he believed he had reached Asia, which was mistakenly. He made no attempt to found a permanent colony. He led another voyage to the Americas the following year, but nothing was heard of him and his ship again. Okay? This is called the Anglo Spear. All right? This is why it's called the Anglo Spear. The first English colony overseas America was made in the last quarter of the 16th century and the reign of Queen Elizabeth I through the Elizabeth settlement. The 1580s saw the first attempt at a permanent English settlement in North America, a generation before the plantation of oysters, i.e., oysters of Scotland. All right? Did y'all hear me? Do y'all follow me? Do you understand me? And concurring a little bit after the plantation of Munster. Soon there was an explosion of English colonial activity driven by men seeking new land, by the pursuit of trade, and by the search of religious freedom. In the 17th century, the destination of most English people making a new life overseas was in the West Indies rather than in North America. Okay, let's go back to this radical title again. Radical title is a concept in the English common law that refers to the crown underlying title to all land held in overseas plantations and colonies. It grants the crown the power to alienate others from the land and to transfer beneficial ownership of the land to itself or others, but by itself does not grant beneficial ownership. Okay? So that means when you're talking about overseas plantation and colonies, you're talking about laws governing referendum and electoral rights. Okay? Referendum and electoral rights. And to understand that, you must understand allodial. All right? You must understand allodial property. Give me 1 second. And it brings me here. The Donuts Conditionalist and the State Tail Act of 1285 is a chapter of the English Statute of Westminster, which originated the law of entail forbidding a landowner to sell the land except to his heirs. Okay? To his heirs. Read the Pretorius. Read the Pretorius is a statute passed by the Parliament of England, not Scotland, not Ireland, not the United Kingdom, but uh, England by Parliament by Edward the First, even before the Jews or the Ashkenazi Jews or the Ulster Scottish Jews, wherever you want to call them, were expelled from England, then expelled from Scotland, as well as expelled from Jerusalem. Okay, they was not allowed to go anywhere where the English possessions under the what we call radical title that was governed under the King prerogative or priority. It says the Queen of Victoria is the statute passed by the Parliament of England in 1290 during the reign of Edward I that prevented tenants from alienating their lands to others by what we call subfeudation. But instead to pass by way of what we call operation of law. Okay? Instead, we can our tenants who wish to alienate their land to do so by substitution, which means that put a new tenant in charge of the old tenant and canceling or severing all obligations of that prior tenant and now are required by the new tenant. The statute, along with its companion statute, are a prerogative writ called cor warranto, which means the order to show cause. In English American common law, cor warranto is a prerogative writ issued by a court which orders someone to show what authority they have for exercising some right, powers, or franchise they claim to hold. The writ of quo warranto still exists in the United States, although it's uncommon, but blah, 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 blah. I'm not going to get into that. All right. So the quo warranto is a writ that the United States took from us. All right. In regards to petitioner right, as stated in Chisholm versus Georgia, to petition the king in regards to some property right or issue that you right that's protected by the king's law. Okay. So a quorum warranto was also passed in 1290 in lieu of Queen Impetuous to also raise the question just in case somebody took land and that you were able to seek remedy by way of equitable relief. This is the reason why you have trial by jury, all right, under what we call the Sides Courts Act of 1166, by way of what we call the Sides Clarendon Constitution of 1164, which was passed by Henry II, the son of God, the fifth cousin of Andrew, in regards to land that was left abandoned as a result of crusades that we went on. And yes, we are still on a crusade. So the king at that particular time put in the laws governing how land is supposed to be conveyed based upon the prescribed methods, contrast to that which is what we call fee simple by the process of what we call common recovery, which is contrary to what King Edward I established under the laws of Quinton Pretoria. Okay? The statute, along with the companion statute called warrant also passed in 1290, was intended to remedy land ownership disputes and consequent financial difficulties that have resulted from the decline of the judicial feudal system in England during the Middle Ages. All right? The name Quibitor derived from the first two words of the statute in the original medieval Latin, which can be translated as because of the buyer. Its long title is the statute of our Lord the King concerning the selling and buying of land. So the Queen of Victoria was a statute from the king concerning the buying and the selling of land or the conveying of land. And that's governed by what we call the statutes of fraud. Okay? Everybody hold that thought. still concerning the Queen of Pretorius. By effectively ending the practice of subjugation, Queen of Pretorius has hastened the end of feudalism in England. All right. So when it ended feudalism, means that there's no tenures supposed to be given out. Okay, that means that the land is allodial now. Okay, if it ended feudalism in England, because feudal tenure under feudalism was done to raise free and common focus for the king, which you call taxes. Okay, you call that tax. It says, so by effectively ending the practice of subjugation, Queen Victoria's hastened the end of feudalism in England, although it had already been on the decline for quite some time. Direct feudal obligations were increasingly being replaced by cash rents and outright sales of land, which gave rise to practice of livery and maintenance or battle bastard feudalism. The retention and control by the nobility of the land, money, soldiers, and servants via direct salaries and land sales and rent payments. By the mid 15th century, the major nobility were able to assemble estates, sums of money, and private armies on retainers through post Queen Victoria land management practices and direct sales of land. It is thought by historians such as Charles Plummer that this then developed into one of the possible underlying causes of the War of the Roses. Other sources indicate the essence of bastard feudalism as early as the 11th century in the form of livery of maintenance, and that the elements of classical feudalism are as significant and late as the 15th century. Background. Why pull this up? Very important. My coffee's brewing. You can read this. Background concerning Queen of Victoria. Prior to the Norman conquest, all right, in 1066. We know we're dealing with the Norman conquest. We're also talking about when the Jews came in with the Norman conquest, not just in England, but also in Wales, not just in Wales, but also in what we call now North America, which was prior to that was called the British Empire, which prior to that was called the English Empire, going all the way back to the overseas possessions under the radical title held by the crown. Okay? So prior to the Norman conquest of England in 1066, the Anglo-Saxon law of land succession was customary. Land of folkland, i.e., son of folk, ruler of Jerusalem, is also called, as it was called, was held in a allodial title by the group, meaning the group held the land. All right? They held it together under the allodial title because the allodial title was held under the king, i.e., the minor. It was probably a little relevance with a titular head of the clan or family died. Okay, it was probably of little relevance when the titular head of the clan of the family died. Traditional lands continued to be held in community by the group. The exact nature of the allodialism as it existed in Anglo-Saxon England has been debated, but no definite end. On the one side, it has been argued that in the Mark system, Saxon allodialism was a highly idealistic social communitarian state. Okay, right here. Go get my coffee. After the conquest, the rule became one of primogeniture. All right. After the conquest, the rule became one of primogeniture inheritance, meaning the eldest surviving son became the sole heir of the baronial estate. The intent of primogeniture inheritance was to keep large land holdings into the hands of a relative few trustworthy lords. The other son could be accommodated by becoming under lords to the surviving heir. The eldest would accept the younger brothers and homies in return for their allegiance. This was a process called subfeudation. Every commoner could subfeudate to their social inferior. Large pieces of land were given to great lords by the Norman crown. Land titles under William was a life tenure, meaning the land would pass back to the crown upon the death of the lord. These lands were then subjugated to lesser lords, pretty much what they call freehold. Landholding in England were of this pattern. Large land grants issued to the great lords by the crown. These were divided up amongst the younger sons, who then subjugated them to lesser lords and commoners. These, in turn, accepted in homage that electors who held even smaller parcels of land determined who owned what feudal incidents filled the court docket for generations. With the passage of time, land tenures came to be inherited by survivors of the great lords upon their death. Accompanying the Norman change in inheritance was a recognition of the ability of even the lowest landowners the right of inheritance. In the 12th century, the custom was extended to the commoners. It was discovered that granting an interest in the passage of land to their children, commoners would tend the land with great economy. All right? Commoners. The children of the tenants were assured their inheritance in the land. This also meant, as practically, the land could be sold or bequeathed to the church. All right? This also meant, as practically, the land could be sold or bequeathed to the church. This ancient method of Norman was a grant to the church and what they call sprinklement. If English law after the conquest, I better pay attention. In English law after the conquest, the lord remained a grantor after the great grant of an estate in fee simple. There was no land in England without a lord. Nulla terra sanguinia was the feudal maxim. These grants were in turn subject to subjugation. The principal incident of signatory were an oath of fealty, a quiet or chief rent, a relief from 1 year's rent, quiet rent, and the right of its chief, i.e., subject to remandment or what we call reversion. All right. In return for these privileges, the lord was liable to forfeit his right if he neglected to protect and defend the tenant or did anything injurious to the feudal relation. The word fee is associated with the Norman feudal system and is contradiction to the Anglo-Saxon or Lolio system. Did y'all hear that? Did y'all hear that? Okay? I hope y'all did. All right, so let's move to our closing. Shively versus Bowlby, 1894 case. All right. Shively versus Bowlby, 152 U.S. 1, 1894. Consider everything that we just talked about in regards to referendum and electoral rights in regards to rights of ownership to the large body of water or small body of waters, such as oceans, seas, rivers, contrast to streams, brooks, etc. And those referendum rights, territorial rights, falling under authority of the crown based off the radical title of the crown, which is called overseas possessions, which we call intel land or crown land, because crown land is intel land, which is personified by the mind, all right, which is inseparable from the land which is in question, all right, because it's part of what we call the public trust, all right. Let's read a little bit about it. The only matter adjudged was upon the counterclaim. The judgment against its validity proceeded upon the grounds that the grant from the United States upon which it was found passed no title or right as against the subsequent deeds from the state and lands belonging below the high water mark. All right. This is a direct adjudication against the validity of a right or privileges claimed under a law of the United States, and the presence and present a federal question within the appellate jurisdiction of this court. See revised statute section 709. That jurisdiction has been repeatedly exercised without objection or doubt in similar cases of writs of errors to the state court. All right. It was argued for the defendant in error that the question presented was a mere question of construction of a grant bounded by tidal water and would have been the same as if the grantor had been a private person. But this is not so. The rule of construction in the case of such a grant from the sovereign is quite different from that which governs a private grant. The familiar rule is the chief foundation were felicitously expressed by Sir William Scott. All grants of the crown are to be strictly construed against the grantee, contrary to the usual policy of law and consideration of grants, and upon this just ground, that the prerogative and rights and emoluments of the crown being conferred upon it for great purposes is for the public use. It should not be intended that such prerogative rights and emoluments are diminished by any grant beyond what such grant by necessary and unavoidable construction shall take away. Many judgments of this court are to the same effect. And at the last term in which the writ of error was dismissed for want of jurisdiction, it did not appear that the plaintiff in error claimed under a grant from the United States. The present case being clearly within our jurisdiction, we proceed to the consideration of its merits. The brief submitted to the court in the case at bar, as well as in the above cited in which now stands for judgment, have been so able and elaborate to have disclosed such a diversity of view as to the scope and effect of the previous decisions of this court upon the subject of public and private rights in land below the high water mark of navigational waters, that appears to the court to be a fit occasion for a full review of this decision and consideration of other authorities upon the subject. Y'all listen. By the common law, both the title and dominion of the sea and of rivers and arms of the sea, where the tide ebbs and flows, and all lands below the high water mark within the jurisdiction of the Crown of England are in the king. Such waters and lands which they cover, either at all times or at least when the tide is in, are incapable of ordinary and private occupation, cultivation, and improvement, and their natural and primary uses are public in their nature for highways of navigation and commerce, domestic and foreign, and for the purpose of fishing by all the king's subjects. Therefore, title, just privatum, and such land as of waste and unoccupied land belongs to the king as the sovereign, and the dominion thereof, just publicum, is vested in him as the representative of the nation for the public benefit. The great authority in the law of England upon this subject is Lord Chief Hell, who the authorship of the treaty de jure Maurice, sometimes questioned, has been put beyond doubt by recent research. In that treaty, Lord Hell, speaking of the king's right of propriety or ownership in the sea and soil thereof within his jurisdiction, lays down the following propositions. The right of fishing in the sea, the creeks and arms thereof, is originally lodged in the crown. as the right of dispatching is originally lodged in the owner of the waste whereof he is Lord, or as the right of fishing belongs to him that is the owner of private or inland river. But though the king is the owner of this great waste, and as consequence of his propriety, has the primary right of fishing in the sea and the creeks and the arms thereof. Yet the common people of England have regularly a liberty of fishing in the sea or creek or arms thereof as a public common piscary, and may not without injury to their right be restrained of it unless it's in such places, creeks or navigable rivers where either the king or some peculiar subject has gained a propriety exclusive at that common liberty. The shore is that ground that is between the ordinary high water mark and the lower water mark. That does primal facies of the common right belonging to the king, both on the shores of the sea and the shores of the arms of the sea. Talking about littoral rights now. And afterwards explains, yet they may belong to the subject in point of propriety, not only by charter or grant whereof there can be but little doubt, but also by prescription or usage, all right? But though the subject may thus have the propriety of the navigable rivers part of a port, yet these cautions are to be added, that the people have a public interest as just publican of passage and repasses with their goods by water and must not be obstructed by nuisance. For the just propertum of the owner of proprietor is charged with a subject to that just publicum which belongs to the king's subject as the sort of an highway is, which though in point of property it may be private man's freehold, yet it is charged with a public interest of the people which may not be prejudiced or indemnified. When a port is fixed or settled by the license or charter of the king, or that which pursues and supplies customs and prescriptions, though the sole franchise of the dominions thereof prima facie be in the king, or by deliberation from him in a subject, yet that just propertum is clothed and a superinduced with a just publicum, wherein both natives and foreigners in peace with his kingdom are interested by reason of common commerce, trade, and intercourse. But the right that I am now speaking of is such a right that belongs to the king, jure prerogative, and is distinct right from that of a priority. For as before I have said, though the dominion either of franchise and propriety be lodged either by prescription or charter in a subject, yet it is charged or affected with the just publican that belongs to all men. And so it is charged or affected with that just regime or right of prerogative in England. From the time of Lord Hell, it has been treated as settled that the title of the soil of the sea or of the arms of the sea belongs below the ordinary mark is in the king's, except so far as an individual or a corporation has acquired rights in the express grant or by a prescription or the usage. And that this title, just privatum, whether in a king or in a subject, is held subject to the public right, just publican of the navigation and fishing. The same law has been declared by the House of Lords to prevail in Scotland. It is equally well settled that a grant from a sovereign of land bounded by the sea or by any navigable tidal water does not pass any tidal below the high water mark unless either the language of the grant or loan usage under it clearly indicates that such was the intention. All right. By the law of England, also every building or wharf erected without license below the whole high water mark, whether soil is in the king, is a perpetuer and made at the suit of the king either by demolished or be seized and rendered for his benefit if it's not a nuisance to navigation. All right. I think Chief Tuskegee made a quote in here too. Let me see. Part two. The common law of England upon the subject at the time of the immigration of our ancestors in this law of this country, except so far as it has been modified by the charters, constitutions, statutes, or uses of the several colonies and states, or by the Constitution and laws of the United States, English possession in America were claimed by right of discovery, having been discovered by subjects of England by subjects of the King of England and taken possession of in his name, by his authority or with his assent. They were held by the king as representatives and of in trust for the nation and all vacant lands, and the exclusive power to grant them were vested in him. The various charters granted by the different monarchs of the Stuart dynasty for large tracts of territory on the Atlantic coast conveyed to the grantees both the territories described and the powers of a government, including the property and the dominion of land under the tidewaters, and upon the American Revolution, all rights of the crown and parliament vested in the several states, subject to the right surrendered to the national government by the Constitution of the United States. So, Constitution of the United States. The leading cases in this court as to the title and dominion of tidal and of the lands under them is Martin versus Waddell, which arose in New Jersey and was as follows: the charter granted by Charles II in 1664 and in 1674 to his brother Duke of York, afterward James II, included New York and New Jersey and the island part itself of Martha Vineyard and Nantucket, and conveyed to the Duke the territories therein described. Together with all lands, islands, shores, rivers, harbors, mines, minerals, corals, woods, marshes, waters, lakes, fishing, hawkings, hunting, fowling, and all other royalties, profits, commodities, and hereditaments. Thereto belong or appertain in all the estates, rights, titles, interests, benefits, advantages, claims, and demands of the king of or to the same, as well as full power of the government, provided, however, that all the statutes, ordinances, and proceedings should not be contrary to, but as near as conveniently might be agreeable to the law, statutes, and government of England. All the rights, all these rights, both of property and of government, and in part of those territories were granted by Duke of York to the proprietaries of East Jersey, and they, in 1702, surrendered to Queen Anne all the powers, authorities, and privileges, and concerning the government of the province, retained their right of the private property. They retained the right of private property. An action of rejection was brought in the Circuit Court of the United States for the District of New Jersey for land under tidal waters in the Raritan Bay and River, to which the plaintiff claimed title under specific conveyances of the land from the property of East Jersey, and which the defendants were in possession for the purpose of planting and growing orchards under the statutes passed by the legislature of the state of New Jersey in 1824. This court, following, though not resting wholly upon the decision of the Supreme Court of New Jersey in Arnold versus Monday, gave judgment for the defendant for the reason assigned and the opinion delivered by Chief Judge Cheney, which cannot be better summed up than in his own words. Right? The country mentioned in the letter patent was held by the king and his public regal character as the representative of the nation and a trust for them. But those charges, in view of the principles stated by Lord Hill in the passage above quoted concerning the right of fishing, the dominion and propriety in the navigable waters and the soil under them, passed as part of the prerogative rights annexed to the political powers conferred by the Duke of York in his hand, and they were intended to be a trust for the common use of the new community about to be established, a public trust for the benefit of the whole community to be freely used by all those navigations and fisheries, as well as the shellfish as floating fish, and note as private property to be parceled out and sold by the Duke for his own individual emoluments. And the judgment of the court, the land under the navigable waters passed to the grantees as one of the royalties incidents to the powers of government, and were to be held by the same in the same manner and for the same purposes that the navigation waters in England and the soils under them are held by the crown. The surrender by the properties of 1702 restored to the crown all its ordinary and well-known prerogatives, including the great right of dominions and ownership in the rivers, bays, and arms of the sea, and the soils under them, in the same flight and condition in which they originally came to the hand of the Duke of York. When the revolution took place, the people of East State became themselves sovereign, and that the character holds the absolute right to all the navigable rivers and the soils under them for their own common use, subject only to the right since surrendered by the Constitution to the general government. Do we understand that? All right. So if that's the case, let's go here before I close out. Saber on the rights under the charge of Great Britain. 61-28. Being Section 12, an act entitled an act to incorporate the trustees of religious society, approved April 9th, 1875, saved from repeal, which means that you can't annul this, you can't amend it, you can't do nothing with this. Why? Because this section vests their property held under charters of incorporations granted by Great Britain and corporations created in place thereof. So what is it saying? That property that belongs to the kings of England under the jurisdiction of the monarch of Great Britain incorporated that property and corporations in place thereof, such as the corporation what you call now the state of New Jersey. Okay? Check this out. This is a statute qualifying the authority we have as the English Theological Church of England. How many religious societies are using statutes to promulgate their protected right? Listen, watch this, y'all. 61-28. Powers of our authority, of our religious society. All right? This is what your religious society should have protected by the government, being that church and state is separated from the government, which is nothing more than the state. So you have government for the state and the government for the church. All right. Most churches don't have a government because the government they have is in the sky and not here on earth. Our government is right here on earth because we got statutory law to protect our government, which is based upon the powers of our government as prescribed by God's law. Okay, which is statutory law because God's law is statutory law, and the statutory law of God's law is what we call the law as governed by Parliament. Okay, it says here the power of a religious society. Every religious society or congregation incorporated by virtue of the laws of the state should have the power to what? Have perpetual succession of such corporation. Sue and be sued, plead and implead by any court, by implead in any court. Adopt or usage of a common seal or to renew the same at pleasure. Adopt such officers, agents, employees as may be required for its properties, institutions, and businesses. Make bylaws, rules consistent with the laws for the regulation and management of its affairs, properties, and institutions. F. Acquire, purchase, receive, have, hold, take by default, bequest, or give without limit real personal property of all kinds, churches, edifices, schoolhouses, colleges, buildings, personages, sister houses, hospitals, orphan asylums, and all other kinds of religious, ecclesiastical, educational, charitable institutions, and the land whereupon the same are or may be erected, and the cemeteries or burial places, and any real estate suitable for any and all said purposes. Did y'all hear that? Lease, grant, sell, dispose of any and all parts of such property, borrow money for the purpose of the corporation. To give bonds and mortgages thereof on any part of the property. Have the management, direction, and control of the civil and temporal affairs of the congregation, church, or parishes. All right. Exercise any corporate power necessary and proper for carrying out the above enumerated powers and the purpose of that corporation and institution. I missed one. Where is this at? Something missing in the section. I think they amended that statute. I think they did. Too late though. Let's make sure. to see if they took a word out of that statute. It was there before. Let's just say, make sure. Now, bear with me. Give me a second. I'm just looking at a document, everyone. Bear with me. I ain't got time to look. Yeah. So in closing, New Jersey Corporation, 61-4. Powers, all right, of our religious society. Government was in here. I don't see it now, but it actually said government, inconsistent with your government. Gotta find it. I'll find it. Bear with me. This is actually the something from the case that I used already. But it's here. Reference to that right guaranteed under 61-4. No, it's there. We just check this other document. If I don't see it, then we'll close that. Right? Just like this one. Reason why I'm not showing the document because it has to do with the case, and we can keep that information private. Yeah, I know that. I know that. I know that. We just thanks for that notice. I don't think I'm fine. Got one more document to check. One more, and then I'll let you. Might be here. Not, I'll let it go. If it's not, I'm gonna need some glasses. He needs some glasses. I ain't gonna find him. We can close out on that. All right. And I'm gonna open the floor for questions in regards to those uh understanding that the Jews who migrated from the Jewish diaspora in the 7th century BC by way of the Exodus, all right, is symbolic of the Jews who migrated to England, who came to England with William the Conqueror under the invasion of William the Conqueror through the Norman invasion. You know, the Norman invasion didn't just take place in England, but it also took place in Wales. All right. We know that those invasions of Norman William the Conqueror uh, uh, um, were preceded by the invasions of Edward the First. All right, in Scotland because of the conflict that Scotland had with England, going all the way back to the All Alliance with Scottish alignment with the Frankish descendants. So it's very important you understand that majority of the information we have here in regards to people's history was was not only told in the biblical references that told by the Bible, which was created by the Scottish monarch under the guidance of what we call the House of Tudors. All right. We know the House of Tudors are nothing more than infiltrators of the Plantagenet cadet branches of the Lancaster and York branches of those houses were established by what we call um, Henry II. Henry II was the founder of the or promulgator of the Angevin crown, which broke away from which came from the Plantagenet crown, established by Henry II, son of Godfrey the Fifth, Count of Anjou, son of Fulk. And we know that all that history in regards to the kings of England and France ruling over here goes back to the treaties and the laws that were made by those monarchs, whether they were de facto or de jure. Okay, so do the Scottish diaspora, which let me just pull that up right quick. Scottish Enlightenment. Scottish Enlightenment, real quick before we go out. Scottish Enlightenment was the period of the 18th and 19th century characterized by outpouring of intellectual scientific accomplishment. By the 18th century, Scotland had a network of parishes, schools, and Scottish lowlands and 5 universities. Enlightenment culture was based upon a close reading of new books, intense discussion, but took place daily at such intellectual gatherings and places in Edinburgh. So once again, we know that the 1911 Encyclopedia Britannica was established in Edinburgh, where the Scottish Enlightenment actually took place. And from the Scottish Enlightenment came the Scottish diaspora, which means they spread the information around the world. Do I have Scottish Enlightenment here? Scottish diaspora. In closing of the teaching aspect, the Scottish Enlightenment had an effect far beyond Scotland. Okay, once again, the Scottish Enlightenment had effects far beyond Scotland, not only because of the esteem in which Scotland's achievements were held outside of Scotland, but also because of its ideas and attitudes that were carried all over Great Britain and across the Western world as part of the Scottish diaspora and by foreign students who studied there. So the information that they received based off their intellectual enlightenment in Edinburgh, Scotland, they took it around the rest of the world, right? We're in on that. Western world. And you can see Western world. Everything pretty much that we know today was based upon what they presented and spread around the world as a result of their enlightenment. And then they confused the world and result of that enlightenment because they know the enlightenment that they were enlightened by was our history, Anglo-Saxon Berber history. All right. So we are the ones, we are the trendsetters, we are the foundation from which ownership of anything is known by. All right. So you must track ownership of this real estate to the original grantor. All right. We know the original grantor of the ownership was, in fact, the minor, the King of England. Okay. The King of England. So with that, I rest on the show and I'll leave the floor open for remarks for all those who got questions. While y'all doing that, I'll search for what I was looking for. All right. Any questions? Wait a couple of minutes. That's good. Countess right. Now that you know that you have a relationship to all those particular nations, now it's time to start the process of elimination. All right, which nation will best benefit you in with your flight of freedom? That's what you should be asking yourself. Okay. Yes, we are related. Yes, but the characteristics of that relation must be sought out. You know what I'm saying? Because even though we're relating, we war against ourselves as a result of not understanding ourselves. All right, the higher self, the lower self, the good and the bad of ourselves. This becomes the problem, and this is why we must have a standard, a government that's put in place to hold everybody accountable. And this is what we put back together, our government. Hold that thought for 1 second. I think I found it. Well said, Archbishop. Give me 1 second, y'all. Gotta be. Oh, it's I don't know where that saying is, but I know I got it. Next time I find it, I'm gonna definitely post it. Definitely do not see it. But anyway, since there's no questions, uh, it's just an honor to be able to be here with you all, to be able to break down this information, which can be confusing for some if you don't understand it from its totality. All right. But with all things, we affiliate our rights, our protection with the body of politics, which is preserved by the de facto government that exists and living off our virtue, which is protected by our body of politics. All right. So the purpose and intent of this meeting is to let you all know that under 61-28, rights citizens of Charles of Great Britain, an act to incorporate trustees of religious society for property held in corporations place thereof. In order for you to regain back your property, all right, that are being held by other corporations, you must not be a part of that corporation. Because if you are, that means you have no inheritable. Okay. With that, I love you all, and I will greet you all as I admitted you. That would be in peace. All right.